Okay, good morning, everyone. Welcome to the Board of Behavioral Sciences board meeting. My name is Max Disposti. I'm the chair of the Board of Behavioral Sciences. Today's August 14, 2020, and the time is 8:40 a.m. This meeting is occurring at various locations pursuant to Executive Order N2520, dated on March 12, 2020. Today's meeting will be conducted using the following guidelines. All participants will mute their microphones or phone during each petitioner's presentation. At the end of the petitioner presentations, the administrative law judge will ask each board member if they have any questions. Board members will unmute their microphone or phone to ask their question. Upon conclusions of your questions, please mute your microphone. At the conclusion of the board member questions, the administrative law judge will allow the Deputy Attorney General and the petitioner to make closing remarks. Upon conclusion of the closing remarks, the administrative law judge will conclude the matter. After each petitioner, the board will take about 10 minutes break. An opportunity for public comments for items not on the agenda will be provided. Please be advised that during this comment period, the board cannot engage in any discussion or take action on any matters that is raised, except to decide whether to place the matter on the agenda of a future meeting. We will now establish the quorum. So Christina, please call the roll. Thank you.
Good morning. Crystal Anthony?
Here.
Dr. Leah Brew?
Here.
Deborah Brown?
Here.
Here. You're breaking up, Christina. I don't know if you're freezing up or not. I believe Christina is having a little problem.
Okay, so
We need to wait for her to come back to finish the roll call. Otherwise, we can't move.
or I can.
Oh, you
So
can.
yeah, Dr. Leah Brew.
Are there Ross? Looks like he's absent.
No, I'm
He's
here.
here.
Can you hear me?
Okay, thank you.
Christina, just for a second. You were freezing up, so we lost most of that.
Okay, so I'll start over, and then
Yes.
during break, I'm going to probably switch platforms here.
Thank you. I appreciate that.
Crystal Anthony?
Here.
Dr. Leah Brew?
Here.
Deborah Brown?
Here.
Max Disposti?
Here.
Ross Ehrlich?
Here.
Susan Friedman?
Here.
Chris Jones?
Here.
Jonathan Maddox?
Here.
Kelly Ranasinga?
Here.
John Sovek?
Here.
Wendy Strack?
Here.
Christina Wong?
Here.
We have a quorum.
Thank you, Christina. We're now moving the public comments of the agenda item. Steve, if you see anyone that is raising their hands future to make a public comment, they have 2 minutes. Go ahead. Steve, can you hear me?
Yes, I can hear you, and it doesn't appear so far. I don't see any hands raised.
I've seen it, Hilarious.
Peter does.
Oh, there we go. Here we go. I'm going to go, Greg. I'm going to ask you to unmute. There we go. Greg, you can talk now. Greg?
Mr.
Oh, here we go.
Matt
Good morning. Can you hear me
Garo.
okay?
Yes, now we
Yes.
Hi, good morning. So my name is Greg Garrow, and I'm an ASW applicant currently in process. I'd like to thank the members of the board for their guidance and service during this difficult time. My public comment is about the statute and regulations code 4980.43, which describes supervised experience for associates or trainees in the marriage and family therapy focus. So Part C of that allows for up to 1,300 hours and a total of 750 counseling and direct supervisor contact hours earned prior to the award date of the qualifying master's degree to be counted toward licensure. So I would like to propose that the board explore the possibility of allowing social work, counseling, and educational psychology associates to count the same number of qualifying hours prior to the award date of their qualifying master's or doctoral degree. And that's it. Thank you so much for your consideration, and be well.
Thank you, Mr. Garrett. Thank you for your time, for being within the 2 minutes. I see someone else, Mr.
Yes,
Yeah.
I've got Peter. Peter, I'm going to ask you to unmute.
Okay.
And you can talk now.
Great, thank you. Yeah, so my name's Peter Slarius. I'm an associate MFT candidate. I also hold the pre-licensed director at large seat on the state CANF board. Thank you for the opportunity to speak to an item that affects a number of MFT associates and that they've asked me to speak about. I do recognize we're in the middle of large upheavals that touch a lot of lives, and I'm sure there are many of these serious things that must be taking up your time. Nonetheless, the matter I bring is still of import for those who seek to become licensed and to help in the service of healing. A great bulk of therapists, registered and licensed, found themselves suddenly needing to embrace telehealth to continue to serve their clients. For associates, these decisions were often made by the clinics and practices where they worked without input or choice. We simply found our work shifted to a new medium. This has had a substantial and detrimental effect on the accumulation of hours towards licensure. For those pursuing option 1, MFT licensure, any hours they were accumulating under couples, family, and children stopped and are now all counted only under telehealth. For those pursuing option 2, the situation is even more difficult. Only 375 hours can count towards telehealth. So not only is the work, even the hours themselves are no longer counted. I've done couples counseling myself via Zoom the last 5 months. If I were still counting hours, I would not have accumulated a single hour towards my requirements for couples, families, and children. I ask that the board give consideration to addressing this situation, not to prescribe, but perhaps by adding subcategories under telehealth that allow counting the hours for what they are and lifting the cap on option 2 telehealth. In closing, we pre-licensees, like many, are affected by the large shifts. We only ask not to be disadvantaged when it's within the power of the board to recognize the good work with good heart that we do every day in support of individuals, couples, family, and children. Thank you.
Thank you, Mr. Salarius. Thank you for sharing your concern with the board today. Thank you so much. Steve, do you see anyone else?
Yes, we have 3 more. I've got somebody with the initial CB. I'm asking you to unmute now.
Yes, actually, it was the same issue as the previous speaker, that I would like my work and other associates' work that's done over telehealth with children, couples, and families to count as work with children, families, and couples towards my license. Thank you.
Thank you again. Thank you for being here.
And then we have Rubin. Rebecca Rubin. I apologize there.
Thank you, Steve. Hi, my name is Rebecca Rubin. I'm an associate social worker in Los Angeles. I joined at the last month's meeting. I'm here to share again concerns and wishes that the BBS and the board will look into online proctored exams. Current testing situations at Pearson VUE sites in the state have been reported, even as of this week, to not be mandating mask wearing, to be generally unsafe. As someone who does have an autoimmune disease, who's a mother myself, I am scared to go into a test site in the near future. And I would, other professions, including lawyers in the MCAT exam, have seen changes as a result of this pandemic, and requesting that you look into finding ways to offer online proctoring. Additionally, the CEO of the National Association of Social Workers just this Tuesday wrote a letter to the Association of Social Work Boards requesting this very same thing. I'm happy to provide the letter if that's helpful. And know that this is one of our NASW Code of Ethics. Within public emergencies, section 6.03, social workers should provide appropriate professional services in public emergencies to the greatest extent possible. Appreciate all of your hard work. I know this is a hard year, and really just want to make our profession as safe and able to continue to help as many people as possible. Thank you so much.
Thank you. Thank you so much for being here as well.
Okay, now we have Kimberly Miller. Kimberly, there we go.
You're muted.
Oh, there we go. There we go. Sorry. Thank you. Thank you, board, for allowing me to take a couple of minutes to speak with you. I was at the last meeting as well. I listened in. Rebecca Gonzalez of NASW California had kind of put this out there to discuss about what Rebecca Rubin just talked about. I started a change.org petition, which is gaining a lot of signatures and concerns for MFTs, LPCCs, and social workers. I am an ASW registrant myself. I work for the County of LA. I work in the correctional facility, Twin Towers, which has been notably known to have a lot of problems with mask wearing with the deputies. I've been working closely with my union because there's a lot of people who have gotten sick. And these enclosed spaces concern me because I am also immunocompromised like Rebecca Rubin. And so I reached out on Facebook and I've received a lot of effort, and Rebecca's really joined me along in that effort. That there's a lot of people very concerned because we cannot get into the testing centers. I have been trying for 5 weeks actually, to get an appointment to go to a Pearson VUE Center for my special accommodations, and I cannot get an appointment. You know, it's kind of a concern that ventilation systems have been found by evidence of doctors and CDC that there is now aerosol-borne potential as far as 30 feet. I just saw that 2 days ago. So our concern is, and we're asking the board to assist us along with NASW California, CAMFT, and the APCC boards to assist us in getting this, allowing us to get online proctor testing for our own health and safety so that we can get out there and serve. I've been out of work for 6 months because of this COVID. And then I'm also up against testing guidelines. So that's all I need to say to you. Thank you, board, for letting me share that information.
Thank you as well for your time. Thank you for being here today. Anyone else, Viv?
That is it.
Okay, so before we move to the our petitioners, I just want to double check with our judge if we have our recorder with us.
The court reporter has logged on. Ryan? And where did he go? Ryan, if you can acknowledge yourself and let us know you're on.
Okay. Anyway, we're still moving into we're moving to the next agenda items, which will be suggestions for future agenda items. This is for our board member. If there are any suggestions, please share it now.
Hey, Max, I don't have a suggestion, but I have a different type of suggestion. There is a Ryan on the call. Maybe someone could send that person a direct message and confirm if that's the court reporter and just ask them to unmute and acknowledge themselves, because there is a Ryan identified here.
Thank you for pointing it out.
Yeah.
Good morning. Court reporter here for the board hearing. How is everybody today?
Thank you for being with us. We're almost about to get to the petitioner in a few seconds. So we were in the public comments agenda items. Again, if there are any suggestions for our board member, I would like myself to reiterate, because from the conversation we had also the past board meeting, if we can definitely make sure that we have our, as suggested in the previous board meetings, if we have our partners for our testing sites to come and do a presentation, that I feel it's really needed as soon as possible at the next board meeting, so that we can actually answer a lot of those questions and concerns that our licensee are bringing forward to the board. So I just wanted to reiterate that. Anyone else? Okay. So I'm actually moving this portion of the board meeting to under the care of our administrative judge and Judge DeCure. Thank you so much for being here, and I'll move this to you.
Hi, good morning. This is Administrative Law Judge John DeCure, and my purpose today is to take us through 5 hearings. We're not on the record yet. So first, I'd like to start with the court reporter Ryan, what's your last name and how do you spell it? And can you please give me your number as well?
Good morning, Judge DeCure. Last name is Sanjeet. That's S-A-N as in Nancy, G as in George, E-E, T as in Tom, CSR number 13520. I do apologize for being a little late, Judge. I was given a 9 o'clock start time, so my apologies.
Okay, thank you very much. So what I'd like to do is I think we've got 5 cases today, and so I'm going to just open the record. I know the board has already taken care of its business, so let's just start with that. Good morning. This is Administrative Law Judge John DeCure. I'm opening the record in actually 5 matters that the board, of which there's a quorum, Board of Behavioral Sciences, is here to review. They are 5 petitions for modifications. 4 of them are directly for reduction of penalties. And these matters are being heard before the board. All board members are present. Since we are a little bit pressed for time, I'm going to just simply state which board members are present very quickly. Chairman Disposti.
Here.
Crystal Anthony.
Here.
Dr. Leah Brew.
Here.
Deborah Brown.
Here.
Ross Ehrlich.
Here.
Susan Friedman.
Here.
Christopher Jones.
Here.
Jonathan Maddox.
Here.
Kelly Ranisinger.
Here.
John Sobek.
Here.
Wendy Strack.
Here.
And Christina Wong.
Here.
All right, thank you. So now that we've all had the board members identify themselves for the record, we have a quorum. What I'd like to do is call each matter one by one. Of course, we're going to take a 10-minute break, and I will tell the court reporter when we're on or off the record. That's something I don't want anyone with the board to have to be concerned with. I'm very used to making a record. So let's begin with the order. I know that we have 5 different petitioners, and it's really up to the chair, Mr. Disposti, how you want to call the cases. Which would be the first one you'd like to hear?
I would like to go with the way we received them. So if Mr. Let me check for a second. Jones.
Anna Jones?
Yes.
Right.
Yes.
Right. Anna Marie Jones. All right. Can we? Hello, Ms. Jones. Good morning.
Hi. Good morning.
All right. This is the matter of the petition for early termination and/or reduction of penalty involving Anna Marie Jones before the Board of Behavioral Sciences. The case number is 2002-017-000-678. The Office of Administrative Hearings case number is 2020-070-584. It's approximately 8:58 in the morning, and we are doing this hearing telephonically before the board due to the national health crisis. I'm Administrative Law Judge John DeCure. May I have an appearance, please, by the Deputy Attorney General?
Anahita Crawford, appearing on behalf of the Attorney General's office.
All right, good morning. So, Ms. Jones, do you understand that you have the ability to have an attorney represent you in an administrative hearing such as this?
I do.
All right, do you choose to represent yourself?
I do.
Okay, that's very...
1 second, Your Honor.
Yes.
I apologize, Judge. Ms. Crawford, by any chance, is there a fan hitting your microphone?
There might be. Are you hearing a lot of feedback?
Yes.
Yes, ma'am. I apologize, Ms. Crawford. Judge DeCure, I took us off the record just for this portion.
Is that better?
Thank you.
Is that any better?
That sounds a lot better for me. How about for everybody else?
Yes, it's all much better now.
Okay.
Thank you, Ms. Crawford.
Sure.
Okay, Ms. Jones, you just told us that you are representing yourself, which is fine. And in fact, I think all of the petitioners are representing themselves. What that means is that you may not at some point understand what's happening with the proceedings, and that's okay. If you hear something between Ms. Crawford, who's a lawyer, and myself, who I am a lawyer before I became an ALJ, and you don't understand it, please don't sit and suffer in silence. Just go ahead and ask. All right. At any rate, you will be able to do anything that a lawyer does, which means that you can make an objection if you want to object to a document. I doubt it very much because most of the documents are submitted on your behalf. But at any rate, I wanted to cover that with you. You will be asked some questions by board members and also Ms. Crawford, and I may ask you a few questions, although I doubt that. We will get to your testimony in a little bit. I might as well swear you in right now. Could you please raise your right hand?
Mhm.
Do you solemnly swear or affirm that in the testimony you're about to give in this proceeding, you'll tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right. I'm going to turn to Ms. Crawford about the documents so that they can be identified for the record. So you'll know what the board is referring to. You can also refer to your documents when you testify. Now, because you don't have a lawyer to represent you, I'm going to allow you to make a narrative statement since you have nobody here to ask you questions to bring out your testimony. A narrative statement is literally just telling your side of the story, essentially, so the board members know why you're presenting this petition and anything else that you think is relevant. The best thing you can do to not leave holes in your testimony is to probably go chronologically, but that's just a generic suggestion that I make to anyone in your position. You can testify however you like. When you're finished, please let us know so that that's when we will turn to cross-examination. Cross-examination is simply people asking you questions. It's going to be one person at a time, and we'll go in an orderly fashion. If you wish to make further statements to explain yourself later when you're done being questioned, you can do that as well. That's called redirect, and I'll ask you if you want to do that. Once you're done with that, you can make closing remarks on your own behalf, and we'll be finished. So are you in a place right now where you're not going to be disturbed? You got a door closed behind you? Okay, excellent.
I am.
All right, Ms. Crawford, do you want to identify what we're dealing with in the record?
Yes, Your Honor. I have provided this exhibit binder also to Ms. Jones. And exhibit 1 is going to be the board memo regarding the probation status of Ms. Jones. Unfortunately, that got squirreled away under AGO 7 instead of being under tab number 1. It's AGO 7 and 8 is where that document is located. And I'd like to mark that as exhibit 1 and introduce it into evidence.
All right, I'm locating it, sorry.
Or you know what, Judge? So we don't have to renumber everything. Perhaps we can just renumber that as exhibit 2A, since that's kind of where it ended up.
You're saying it ended up at the end of exhibit 2?
It did. It ended up in the end of exhibit 2 under AGO 7 and 8.
All right, I'm looking at it right now. Okay. All right, exhibit 1 is the jurisdictional documents in the case. I'm sorry, the memo regarding probationary status, that's marked. 2 is the notification of hearing to the petitioner. I know that worked well because she is here and ready to go. That's also marked. And 2A is pages 7 and 8. That's marked as well. 3, what I have is the certification of registration history. This is another jurisdictional document. Ms. Jones, jurisdictional means these are all background documents that provide the underpinnings for today's case. Okay. 4 is the petition for early termination of probation that you filed with attachments that you included. And 5 is another jurisdictional underlying document, the stipulated settlement and disciplinary order and the statement of issues. Those are all marked. Do you have any objection to exhibits 1, 2, 3, 2A, 3, 4, and 5 being admitted in evidence?
No, it's a little confusing. I do have I'm trying to follow. I do have the document that Anita sent me. I have it on my phone right now, and then I also have it on my screen just to try to make this efficient.
All right.
It seems that everything is there, but if there is something that's not, I will say something.
Well, if you wanted to add something, we can talk about that. But for now, this is the record that of documents that the board has before it. So
And I know I did email yesterday a new document based upon the devotional I co-authored.
I saw it.
Okay, awesome.
Okay, I'm not sure if the board members saw this. It's a one-page, I think it's one page. It looks like something that's glossy that's meant for the public to consume that has your name as a co-author of something. Is that right?
Correct.
Right. Just Ms. Crawford, do you have a copy of that?
I do.
Okay, could we mark that as 6 and admit that?
Certainly.
Okay, so that's marked as your exhibit 6, Ms. Jones. I did see it. It got filed electronically with OAH, which means that I know the board sent it over. Ms. Crawford has a copy of it as well. I hope the board members do. If not, they can certainly get a copy before they deliberate. All right, so 1 through 6 are all marked and are received in evidence. That being said, I want you to go ahead and take a deep breath, relax, and give your narrative, which is, again, you're just telling your story to the board. And in the rare instance that you may hear someone say objection, just stop talking. It might happen. Ms. Crawford is a lawyer and she has the ability to do that. But otherwise, go ahead and give us your narrative statement. When you're done, let us know. Thank you very much. Go ahead.
Your Honor,
Yes.
if I may, I would prefer to give a background of the case first for the public and for the board members.
If you like, it's like an opening statement. That's just fine. Go right ahead.
Yes, thank you, Your Honor. This is Anahita Crawford. I am a Deputy Attorney General appearing on behalf of the state of California. I'm appearing pursuant to Government Code Section 11522, and I am here to assist the panel in fact-finding. My role is not adversarial. It is intended to protect the public interest, and I'm here to ensure the panel has adequate information from which to make a decision. By way of a brief background, the petitioner was issued her Associate Marriage and Family Therapist registration on March 21, 2018. On September 12, 2016, petitioner applied for an Associate Marriage and Family Therapy registration, which was denied. A statement of issues was then filed on November 8th of 2017, which alleged the following. That in 2004, the petitioner was convicted of a DUI and underwent a 6-month alcohol program. She was convicted again in 2005 with a blood alcohol level of 0.12 and underwent an 18-month alcohol treatment program. In March of 2008, she was convicted of public intoxication when she broke into a person's home while intoxicated and is alleged to have hit the individual and destroyed his property. Her blood alcohol level at that time was a 0.12. In October of 2008, she was convicted of her 3rd DUI with a blood alcohol level of 0.13 and designated a habitual traffic offender by the court, and also underwent another 18 months of alcohol program. In May of 2010, the petitioner was convicted of driving on a suspended license. For disciplinary purposes, the board did consider that in 2017, the petitioner was convicted of battery, which was subsequently dismissed through diversion. Effective March 22nd, 2018, a stipulation placed petitioner's registration on probation for 5 years. She was ordered to participate in a psychological evaluation, psychotherapy, relapse prevention program, remedial education, biological fluid testing, and a dependency support program. The petitioner is fully compliant with her probation terms, and 2.5 years remain on her probation. Thank you, Your Honor.
Thank you very much, Ms. Crawford. And I'm going to ask you at each one of these hearings to give an opening statement. That was extremely helpful. Ms. Jones, you may proceed with your testimony. Go ahead.
Awesome. Well, first, I'm just truly honored to be here today. This has been an interesting journey, as you guys can see on paper, but I have overcome many things to be here, and I'm truly proud of who I am. I've typed something up just to kind of make it easy, because as you see, I'm getting emotional. But I'll get through this the best that I can. Whew. Okay. I am Anna, a name truly that I hold close to my heart, a name that shaped my identity and my spirit as a person, the name that my parents chose for me when they adopted me. My name means grace and favor. It's a name I don't deserve in a spiritual sense, yet a name that I have been so beautifully blessed with. The reason why my parents chose to name me Anna is because they believed wholeheartedly that it was by God's grace that they were blessed to adopt me. A journey that's been filled with ups and downs. As you clearly see in the opening statement, throughout my life, I've made many mistakes. I've accomplished some pretty cool things too. I've had disappointments, have disappointed others, yet throughout my life, my name has given me hope, blessings, comfort, promise, identity, strength, and peace in some very, very challenging times. I not only acknowledge that I personally have experienced the mighty grace of God, I so clearly see that due to grace, I am in front of you guys today. An opportunity that I do not take lightly, and that I do know comes with great responsibility. During 2004 and 2008, the bulk of my legal history was a really, really tough time for me. It was interesting, it was difficult, it was painful, it was filled with naivety, foolishness, shame, identity confusion, sadness, anger, regret, and remorse. It's important I give a brief back history so you can understand me more fully. I'm biracial, transracially adopted. I grew up in Irvine, California, where there weren't many young girls who looked like me. I went to private school, played sports, was a Division I college athlete. I played softball, yet was carrying around sadness and loneliness behind not fully knowing who I was, and so desperately trying to find my way and not feel so alone. In this process of confusion and rebellion and pain, I had way too much fun escaping from my feelings throughout college. And during that time, unbeknownst to me, I was cultivating addictive habits, abusing alcohol, and suppressing my pain. In 2004, I was 23. I'm 39 now. I graduated from the University of Wisconsin. Again, was a softball player, go Badgers. And I was now back in California. I had went through some really difficult experiences in college with some relationships, and just was going through a lot of pain and a lot of shame. And I was having a hard time coping. I was home, I just graduated. You know, you should feel great, right? I have a degree from a great university, had a lot of really awesome experiences. Yet being that I was an athlete, all my friends were around the country. And so when I came home, I was very, very lonely. Reality set in. After graduation, I was now 23, and this is when reality really started to hit. During that period, I graduated in 04, and then in 04, I got my first DUI. That was really, really painful for me. I was the first person in my family to ever have any legal issues. With the adoption, I felt like I had let people down. And I was dealing with a lot of people in my family drink. So it was really, my first DUI, I kind of chalked it up to, you know, this can happen to anybody. And so a year went by and I got another one. At this point, it was 2005. And I was devastated, but I really, I told myself this is not going to happen again. I didn't drink for about 3 years or 2 years. And then I want to speak to something that was mentioned, the public intoxication. I think it's really important because I believe that was in 2007. And if not, correct me. This is a lot of pressure right now. The person was actually a gentleman that I was dating, and it wasn't some random person. He wasn't a good guy. I actually took him to court and testified against him, which is why my charges became public intoxication. He had stolen from me. He had put my body at risk. And when I confronted him about it, he called the police and pretty much blamed me. So I think it's important to note that that was a person I knew, a person that had betrayed me. It wasn't somebody random. And I took that case to court and told my story. And the jury saw fit to reduce it to public intoxication. So after that, that was a very traumatic experience for me. Again, I said he put my body at risk. I won't get into too many details, but after that, I was depressed. And then in 2008, I got another DUI. It was during that time that in 2007, you know, it's interesting enough that during that time when I was going through the DUI courses, at this time I had no plans of getting my master's degree. I had no plans of being a therapist. Even my journey is pretty interesting. When I eventually applied for my master's program, after I finished my first year, I actually thought about changing to organizational psychology. I had no idea I was going to do therapy. I was confused. I was like, I wanted to get a master's in psychology. What's this clinical piece? And so I went through that process, and it was confusing. However, I knew at that time that God wanted me to help people. So in 2008 was my last DUI. As you know, in 2010, I drove on a suspended license, which was stupid. However, it is very difficult when you're in the system. It is a very trying time, not being able to drive and get to where you needed to be. And I made another mistake driving, trying to get to work, and I was stopped by the police, and they cited me with that misdemeanor. So I'm going to try to speed this along, but so.
Excuse me, this is Kim Madsen.
Sure.
If we could just take a pause for a moment.
Yeah.
The Deputy Attorney General has lost her connection and she's trying to log back on.
Okay.
Thank
Okay,
you.
Let's just
God's
go off the
timing.
record until we've got her back.
Okay.
And in the meantime, Ms. Jones, the best thing to do is breathe as
Yes.
slowly and deeply as you can. That helps the most, I think. All right.
Once she's back, once she has logged back in, I'll let you know.
All right, thank you.
Thank you, Kim.
I need it.
Okay, I just saw Miss Crawford and I have admitted her into the meeting. Anahita, she's trying to join now. Anahita, are you on the line? Let's see.
I see her.
Okay. Okay, there she goes. Hi, Anahita. Are you back in?
I think she's freezing up.
Oh no.
Yeah.
Here she is. Unmute.
Oh. Hear me?
Yes. All right. Miss Crawford is back on the line.
I am unmuted.
Alrighty.
All right, we're back on the record, and we're still hearing direct testimony from Ms. Jones. Go ahead.
Yeah, did not think I was going to get so emotional today. Whew. Okay. So the reason why I bring some of these things up, that it sounds strange.
I'm so sorry, Miss Jones.
Oh, it's okay. Should I continue? Okay. So the reason why I bring that up, it was when I was going through those DUI classes that that I knew God really spoke to me clearly that he wanted me to help people. But at that time, I just didn't know in what capacity that would be or what that would look like. I still had a journey to continue and I still had things to resolve, and that's okay. I see very clearly now why God has led me here, but it has been a very humbling and trying process, to say the least. So I have to be honest about this. When I first started this process, I was frustrated. I was hurt. I truly felt it was somewhat unfair that I had to go through everything I've already done legally over and over and over again. Even today, you know, speaking to this, I've spoken to this so many times, and as you can see, it's still painful. I've had to kind of resolve my personal life with my professional, and it's been very, very humbling. The other thing I want to speak to is, you mentioned the 2017 issue that was dismissed that had to do with my sister. And this was very difficult for me because this was a sisterly quarrel that went too far. My sister and I haven't had the best relationship throughout my childhood. She caused me a lot of pain, and she actually submitted a letter of reference. I think I've been a very supportive sister to her. I've definitely made a lot of mistakes. But she tried to take back that night, but once she had called the police, it was too late. But she fully regrets that night, and so do I. But I do think it's important to note that it was with my sister. Again, it wasn't somebody random, and there is a deep history there. And we are in good standing today. I have forgiven her. She has forgiven me. But I truly believe the enemy was trying to use that night to take me off course, and I won't allow it. I stand here in front of you today, you know, determined and resilient. But as I mentioned, you know, this process has been very humbling. Yet throughout it, I've navigated this process and I've surrendered. It has been such a blessing in my life being in front of you today. Again, this probation journey has filled me with humility, patience, sacrifice, knowledge, wisdom, accomplishment, and growth. I've come to realize with great confidence that God has not only been protecting the consumer, my clients, but he's been protecting me in my professional journey. He's used this process, and he's utilized you, the board, to remind me of where I've been, how hard I've worked, and where I am. And he continues to empower me to trust him and be a woman of faith and integrity. God is so good. And I want to reflect that when I went through the DUI courses and got a taste of the mental health realm, that's when I knew I was supposed to help people. But again, I did not realize it was going to be therapy. He led me here. I even rethought this path multiple times. And when I was presented with the stipulated settlement, my dad actually told me not to do it. He said that you've done enough. You shouldn't have to relive this and relive this. But I knew in my heart, this was the journey that I was supposed to take. A humbling one, at times an unfair one. It's been very financially taxing, but I've been committed. Before I close, I want to reflect that it's been 10 to 16 years since the bulk of my legal issues. I was just the glimpse of the person I am today, yet still fully me at heart. I've had interesting life experiences that I've had, plus the education that I've given, and now the clinical experience that I possess. And I truly know that I am an asset as a therapist, and I'm equipped to counsel. I've seen many things in my life, and by God's grace, it's cultivated so many things within me: insight, strength, and resiliency, as I mentioned before. I don't quit. When I mess up, I take ownership for my mistakes. I face them head on, and I know that this process was necessary for the board to look at my past and see if I have been rehabilitated and been able to kind of do my duties as a therapist and a clinician. Yeah, I think that's all I have.
This is Judge DeCure. Thank you. What I'm going to do at the suggestion of another administrative law judge that worked with the board recently is surprise all the board members and go from the bottom of my list to the top with questions. So I'm going to start with Ms. Wong. Do you have any questions for Ms. Jones? If you do, go right ahead.
She's on mute.
She was really surprised.
I was surprised to go first. Expecting that.
All right, Christina Wong, do you have any questions?
Yes, I do. Okay.
Go ahead.
Thank you so much. And I apologize for not able to click it to unmute myself. So Ms. Jones, I want to really, really thank you for coming here today and share, your story. So from age 24, to now 39, I think that 15 years definitely, seems very ups and downs, but also very enriching. And so, so it looks like, you did go through, what the board asked you to do, for, all the terms and conditions. And so, so I just want to check in with you about, the kind of like the change, because you definitely painted, a very confused and, a lot of the struggles when you were, in college. And even during the teenager, and also I think a big part of it is being an athlete. When you're in a D1 school, the pressure is really, really on. And now, fast forward 15 years later, now you are, you're definitely what you're described by your sister. Very eloquent, very professional. And so I want to just help, just want to check in with you. Now if you look back to the past. What is your take? What is the things that you think that you would have done better, and not leading, and in order to change history?
I mean, I wouldn't have touched alcohol. I think, you mentioned being an athlete and being in college. I mean, it just cultivated alcohol abuse. And I grew up in a very Christian, conservative home, very sheltered. And so when I went away to college, it was pretty eye-opening, and I was pretty naive, as I mentioned. And again, didn't expect myself to be on this clinical path. And so I was pretty reckless. I think when we're younger, we think we're invincible, even if we don't consciously connect to that. We're just living life. And so I think what I would do differently is really live out my faith. I'm a Christian. I think I would have gotten help sooner. Sought therapy sooner. I had a lot of shame. And as I mentioned, many of my family members still drink. So I think I was trying to do it on my own. As I mentioned, after the first DUI, I mean, I'm 23, I didn't drink for a year. And then I got the next DUI and I stopped drinking for 2.5 years. So I knew in my heart I was abusing the substance when I did drink, but I knew that there was hope. I knew that there could be recovery, that I could move away from it, but I felt very alone in it. So I would have sought more professional help sooner. I would have maybe separated from family in different ways around the drinking, because that just cultivated a lot of pain. It was kind of in my face. And again, I kind of carried this alone for a long time. But honestly, so those are things from my human perspective that I would do differently. But from a spiritual perspective, from a clinical perspective, everything that I've been through has made me into the person that I am. It has given me a profound empathy for my clients, a deep understanding for the pain that they go through, and also a genuine belief that you can overcome anything. You know, most people, when they have multiple DUIs, and I know Anita mentioned being a habitual offender, this is true, but that is not the end all be all. But most people don't come back from that. You know, most people who go to jail, once you're in the system, it's not only demeaning, it's really hard to get out. Thank goodness I do have a very supportive family, even though they have their own stuff. I know that I am loved and I know that they're there for me. So I think there's some very logical, practical things that I would have done differently by seeking help quicker, maybe taking some things a little bit more seriously when I was younger and not trying to do it on my own. But ultimately, it's led me here. And I believe that I am a better clinician because of everything that I've been through and a better writer.
And I want to thank you for, providing that very deep insight. And I'm sure that, with your experience, you can actually build a much deeper empathy with them because of, what you have been through. I think, when you can share with them that, this is a life example, I have done it. And so I think definitely, it will make you, a much more, much better clinician. So thank you very much. I have no further question, Your Honor.
Thank you,
Christine. Thank you. Ms. Jones mentioned our Deputy Attorney General, Ms. Crawford, and before I go through the rest of the board members, I do want to give Ms. Crawford an opportunity to ask her questions. Ms. Crawford, go ahead.
Thank you, Your Honor. Good morning, Ms. Jones.
Good morning.
I know that your last case was in 2010. And I apologize if you already said this and I missed it. Was that the case that involved your sister?
No, the 2010 was the driving on a suspended, which is the least of all my convictions. I know.
Oh, I'm sorry.
Yeah.
It was the 2017.
Mm-hmm.
Is that a yes?
Yes.
And she wrote a letter of support for you for today's hearing date. Is that right?
Yes, she did. And she actually, when that night happened, she has verbalized to me that, again, we have a very convoluted history. She was going through a lot of pain. She's adopted as well. And tended to take things out on me growing up. As she mentioned in the letter, that I've always been there for her and I'm very supportive. But I've had a lot of pain around that, a lot of trust issues around that. And that night we were separated. She kind of got in my face and I just had enough. And when we were separated, that's when she called the police. She's verbalized to me that she knew she shouldn't have called them, that I did not deserve to get charges pressed against me. And even the next day, she tried to call the police station to say, you know what, I don't want to do this. But at that time, it was too late. So I did get a lawyer for that case and he explained the situation and the judge did see fit to dismiss it. But that was in 2017. I truly believe wholeheartedly that that was a tactic of the enemy, trying to destroy what I've accomplished. But I continue to push through but that was a very, very painful experience for me.
Okay, thank you. Are you on criminal probation for any case at this point?
Nope, I haven't been on probation for a long time.
Do you remember when your last probation ended?
Gosh, in 2008 was I know with the case and with the 2017 because it was dismissed, so I can't quite, I know there was like a probationary period, but then the case was dismissed, so I don't. Last DUI, I believe that may have been like a 3-year probation, but I'm not quite sure. But I've been off probation probably since 2011, 12. Okay. I don't know for sure.
And do you consider yourself an addict?
I consider myself a new creation in Christ. I do consider myself a human being who has abused substances and who has had an addiction in the past, but I do not drink. I do not have a desire to drink. And again, as I mentioned before, this process through the BBS has been a blessing. It has been a great reminder of where I've been and where I'm trying to go. But I do consider myself, I've been addicted in the past, definitely. And I have a tendency towards, addiction if I were to consume alcohol.
Do you know when the last time you consumed alcohol was?
Gosh, it's been, I want to say maybe 3.5 years. And then before that, there was a long stretch of time where I didn't consume.
Okay. And when we look at your history, and you're right, it was primarily in between 2004 and 2008. There was DUIs and alcohol-related offenses, but you were also involved in pretty extensive rehabilitation programs as part of those offenses.
Right.
But you continued to offend and you continued to drink. What is different today that has stuck with you about sobriety that did not register when you took an 18-month course in 2005 and again in 2008?
I think I was young. I mean, it was pretty concentrated. If you think 2004 to 2008, 23 to 26 years old, I mean, I was pretty young. And I was in the midst of it. And I don't know if anybody here today has ever been in the system, has ever been to jail, but it is a very shameful and dehumanizing and painful process. To be in the system, not many get out of it. And not only was I in the legal system, I now feel like I've actually been through the board system. And, when I first started this, it was a little bit traumatic because I was like, I've already done this. I've already done so many of these things and I had to redo them. And so the shame of that overtakes people. So I think what's been different is when I was younger and when I was in the midst of it, I had a lot of shame. I did not have the tools or the resources. DUI programs are very different than therapy. It was, I don't think I understood the weight of what I had been through and what I was going to continue to do. I never thought after the first one I would get another one. As I mentioned, I didn't drink for a year. But then it happened again. And so, I think I'm more mature. I have more to lose. And I actually have a career path and a mission and a purpose in life. As I said in the past, I had a lot of identity confusion. I didn't know who I was. The adoption was really heavy on my heart. And there was just a lot going on. But now that I'm 39, I know who I am. I know my talents, my strengths, my abilities. I know that I am loved. I know that I am worthy. A lot of that shame has just dissipated. But as you guys know, within dysfunction, within addiction, when you're in shame, it just creates a shame cycle. And it's really, really difficult to get out. But now I can say that I am.
Ms. Jones, this is Judge DeCure.
Sure.
I can tell you're testifying earnestly and sincerely and putting everything forth. What I want to suggest is that due to time constraints, what I would like you to do is listen carefully to each question.
Okay.
And answer the question. And when you're done with that question, be glad that you're done with that question and wait for the next one, because right now it strikes me that you're going a bit beyond answering each question, and that puts a lot of pressure on you. It also puts pressure on the board to get through its business.
Okay.
And I want the other board members to be able to ask questions as well. So listen very carefully to each question, answer the question, and then just wait for the next one. That's all you got to do. All right. Thank you. Go ahead, Ms. Crawford.
Thank you, Your Honor. Ms. Jones, I wanted to get kind of a better understanding of that difference between then and now. So you did say that you stopped drinking altogether about 3.5 years ago. So sometime around the time of that last conviction that was dismissed. What have you experienced since obtaining sobriety that has helped you maintain that sobriety from alcohol?
I think solidifying my career path, utilizing my resources, therapy, maturity, just taking ownership of where I've been and where I am. You know, having the humility to say, you know, I've made mistakes, but I want to walk down like a different path. And again, I decided to go towards licensure. One of the reasons why I waited so long to get my registration number is because so much time had passed. And I knew that this was the direction that I was supposed to go in before I was confused. So I think it was my professional career path as well that really kind of helped me make different decisions and has changed me.
Are there triggers that you've been able to identify? And if so, how do you avoid those triggers?
Yeah, I mean, I think being just in the midst of, I mentioned earlier, just putting up boundaries around family, around values. I think being in the midst of any sort of dysfunctional processes that don't align with my values, I've really tried to protect myself from. I think a lot of the emotional triggers that I've had, I'm working on in therapy. I see my therapist twice a month, and I really enjoy that, not only to just express my emotional pain. I think for me, I'm a pretty strong individual, but I tend to kind of keep things in because, you know, in this field, we're there for other people. So I think some of my triggers are, you know, just making sure that I'm talking through my emotions and expressing my pain and going to church, doing those things that I know I need to do to kind of support myself.
Okay. You are seeking termination of your probation about halfway into it. So there's still 2.5 years remaining. How would early termination affect your life or practice?
I mean, in such a big way. I'm actually completed all my hours, and I am going to be taking my licensing test within the next month or two. You know, it's very taxing. I mean, it's very difficult to complete this process and work and do everything that one needs to do. So I think early termination would not only just allow me to breathe, but I also feel because my convictions were so long ago, 2004 to 2008, you know, there's a deep part of me that does not think it would be fair to be on probation when I'm licensed, when all these things happened before I even wanted to enter the field. So it would be very freeing. It would be validation that all my hard work has really paid off. And, you know, I think I deserve it.
Okay. I know that you have mentioned that 2010 driving on a suspended license was kind of least of your problems. But I want you to address the concern that actually has for the board, which is after being designated a habitual traffic offender, you actually continued to demonstrate why you were designated a traffic offender with your 2010 conviction. And that shows the board a propensity to not follow rules, to make poor judgments. Along with your 2017 disciplinary consideration, even though that wasn't a conviction, it still demonstrated potentially bad judgment up until just 3 years ago. So how do you assure the board that terminating your probation early is warranted because you are not someone who displays bad judgment, that you've learned from those mistakes of not following rules and disregard for law.
Well, I think when somebody's under the influence, the disregard for law is genuinely oftentimes unintentional. When I am of, sober and clear mind, I do have a regard for the law and for myself and for others. And I think that's where when somebody is not sober, those things come into question. I made that reference around the 2010 driving under the suspended because, at the time I was actually going to grad school. I was riding a bike every day to and from work. And I actually worked at a restaurant like 2 minutes from my house. And I did not have a car. I was actually not driving. And I got called into work. And they asked me if I could come in last minute. And my roommate said, "Oh, you can take my car." And she did not know about my history. And in that moment I made a decision like, it's so close, it's hot, I'm going to get there. And I think sometimes we don't know the circumstance behind why people make certain decisions. However, I know that it is serious, not following the law. Yet I know in that instant, that day, that I was sober. I wasn't intending to hurt anybody. I was trying to get to work, but it was foolish. And I got caught. I don't really get away with anything. That has definitely been an ongoing joke in my family. I get caught for everything. But so what's going to be different? Again, I have so much to lose. Before I did not know my career path. I had no idea that this is what I would be doing. And now that I'm doing this, I've worked very hard and I have a lot to lose. And I think I've proven over the past, since I've had my associate number, but even over the past 4 years in the position that the job that I have, I've been promoted every year. The owner of my company and my boss wrote letters of reference. But I've proven that I'm responsible, that I follow their policies and procedures, and that I can follow the law. And so I think I've proven that. And I'm more mature. I'm ready to move past it all.
When did you decide to go into your current field and start going to school for that?
So that in 2007, almost 8. And that's when I was going through, again, that issue with that man that I was dating. And it was just pretty awful. He was pretty much a con artist. That's when I was in a DUI course and I knew I was supposed to help people. But then I had a little bit more to go in my journey. So I actually withdrew from school. I had to kind of deal with the consequences of my 2008 DUI. And then after all that, I was kind of free and clear. And that's when I really finished my master's program. I graduated my master's in 2013, 14. But even still, then I wrote a book. I co-authored a book. Even at that time in 2016, I did not know I was going to go towards licensure. And so it was really in 2000, it was really when I applied for my registration is when I was like, okay, it's time. This is what I think I'm supposed to do. I thought about getting my doctorate. I want to write more books. So I would say 2018 or 2017 is when I applied. So it was around the time, even what happened with my sister, I still was like, you know what, I'm not going to let this stop me. I'm going to move forward.
And finally, I want to know what drew you to this field. What caused you to seek licensure and do what you're doing?
My purpose, my gifting, the mistakes I've made, my testimony. And, when I applied for Vanguard University, that's where I got my master's. I knew that's where I was supposed to go, but I was very naive to what that even entailed. I thought I was just going to get a master's degree in psychology. I didn't understand the course of clinical psychology afterwards. However, I love counseling. I love supporting people in their pain. I think I have a natural gift for discernment and empathy, and connecting to people's deep-rooted pain. So, but ultimately, this is where God is calling me to go. And I'm just following.
Thank you. I don't have any further questions.
All right, this is Judge DeCure. Let's resume with questions from board members that may have them. Wendy Strack, do you have any questions?
Sure, just 2 quick ones. Thank you for being here. Do you have a sobriety date?
You know, I think I mentioned 3.5 years ago, but I really, you know, what's interesting. I was thinking about this the other day, and I look at when I got my registration number as kind of March 2018 is when my life kind of changed. The course of my life, I knew that it had to change. I'm more into Celebrate Recovery. I definitely respect AA and the basics of its model, but I don't own, I am free from alcohol. I do not own alcoholism. But I think I would say March 2018 is when my life changed. And when I was really kind of set on this course is when I was awarded my registration number.
Okay. And after probation, if you receive the early termination, do you plan to drink again?
No. I had mentioned a couple of times that this process has been a blessing. And when I first started this process, I was frustrated. But it has reminded me of who I don't want to be. So I do not plan on drinking. No, and I don't want to. I feel free of it. And I see a lot of people drinking and they're miserable. I even know a lot of professionals that drink and they're miserable. And I have been so clear-headed and so grounded. And I've been recently promoted to program director at my job. I mean, God continues to open doors and bless me because I am walking the walk and not just talking the talk. So I do not plan to drink and don't want to.
Okay, thank you. That's all the questions I have, and congratulations on your promotion.
Thank you.
This is Judge DeCure. Moving on to Mr. Sovic. Do you have any questions, Mr. Sovic?
I do, thank you. And just, I want to confirm before I start addressing you, your pronouns that you'd like me to use?
Oh, she.
Thank you. So thank you again for your honesty and integrity in this conversation today. It's been beautiful what you've shared with us in a very difficult moment and a very open forum. So I want to just respect you for that and say thank you. I do have a couple of questions.
Sure.
Do you see yourself, I hear and understand your statements about what AA does and does not mean to you. And I want to understand, are you going to be continuing any type of dependency program support for yourself? And if so, what might that be?
Definitely. Like I guess what I mean by that is I respect AA and I do attend AA meetings. I still do that. And I attend Celebrate Recovery meetings. I'm involved in my church. So I do plan on getting support through therapy and other means. My faith is really fundamental in this process. I hope I just answered the question.
Thank you. Also, earlier on, Ms. Crawford had asked you about the dependency education programs you had gone through the court mandated moments. And I also saw in your record that in your probation here that you were asked to take an education program as well, and that you completed that in January of June of 2019. Yep. And I was curious to know, what did you learn new or unique in that program that applies to this new version of yourself that you're sharing with us today?
It's interesting. I feel like a lot of things I learned in that class I knew. However, I did get an A in that class, by the way. The professor was awesome. Just want to throw that out there. I think what I learned new is how to navigate addiction through counseling and clinically, but also that as a clinician, as a counselor, we are held to a higher standard. And, you know, I think really through this process, what I've learned is I can't just talk the talk, I have to walk the walk. And as I mentioned before, I get caught. And it has been pretty painful for me. And to have to constantly face these things, and I do. But I think what I learned the most was it's not just about learning, it's not just about helping others, it's about applying it to your own life, and living it out. And, you know, sadly, I know a lot of people who don't. And I am humbled that I've been given the wisdom and understanding and insight, and the ability, like the belief in myself to be able to do that. So I think that's what I learned in that class was I can't just learn it, I have to be it.
Okay. And then one other thing that I want to ask you, just a final question.
Sure.
When I was listening to you speak in your opening statement, you talked about in the past you've made a lot of mistakes.
Yeah.
And in addressing those past mistakes, you often used a phrase, at least as I heard it, that I made poor choices. And I'm wondering what you do currently when you get in a situation where you're asked to make an immediate response to something, and how do you now process to move through to make more effective choices in those moments?
That's a great question. Discernment, wisdom. I just, again, I think maturity. When you're put in situations over and over and over again, you learn. You learn how to work under pressure, think critically, deductive reasoning. So many things come to mind, but I do believe I have discernment and the gift of discernment. And so that helps me navigate making difficult decisions with clients or managing my team. But ultimately, I'm more of a stable person. I know who I am. I'm more grounded in my faith. My faith is very, very important to me. And that helps me navigate difficult circumstances and situations. I don't act impulsively. But typically in the past, when I did act impulsively is when I was under the influence. It wasn't when I was of sober mind. So I think just everything I've been through, I've learned how to apply it more efficiently and more effectively.
Okay, thank you so much.
Yeah, you're welcome. Thank you, John.
All right, this is Judge DeCure. Moving on, I want to ask if board member Kelly Ranesinger has any questions. Mr. Ranesinger, if you heard me, you might be still muted.
Thank you. Ms. Jones, can you hear me?
I can't see you.
Okay.
Oh, where are you? I'll just look at oh, yes.
Ms. Jones, one of my concerns in reviewing your petition and testimony was that you concentrated a great deal on the alcohol-related offenses from 2004 to 2010. The incident with your sister in November of 2016 was also alcohol-related, right?
I mean, there was alcohol involved in both parties. Yet I truly believe it was more deep than that. You know, but yes, I mean, I don't want to make excuses and I don't want to sugarcoat anything.
So on examination by board member Strack, you noted your sobriety date was March 2018. After the November 2016 incident with your sister, did you continue to drink?
No, I did not. What I said is I don't have a specific sobriety date, but I do look at, because I just don't, to me, that's a lot of pressure. And I find in the AA model and process when people, it's just a lot of pressure.
Okay, let me stop you there. I'm going to ask my question again.
Sure.
After the November 2016 incident with your sister, did you continue to drink?
I did not.
Okay. And I just want to ask this last question.
Sure.
This is kind of a softball question though.
Okay.
Because when I was looking through your letters of recommendation, I was very impressed that you included a letter from your sister.
Yeah.
And I just wanted to read you the section that I had highlighted.
Okay.
One of the things that I'm most proud of my sister is her unwillingness to give up. No matter what obstacles she's encountered, she always gets back up and faces challenges head on. She's determined to be the best she can be. In my eyes, she's already there. I'm proud to know her. I'm proud to love her. I'm proud that she loves me. She is a gift. That's a hell of a recommendation, Ms. Jones.
Yeah.
Yeah. I was very impressed by that. No further questions, Your Honor.
Thank you.
Thank you very much, Mr. Ranasinger. And based on how tight your questions were, I wish you well while you're studying law at night. Mr. Maddox, do you have any questions?
Yes, I do. Thank you. Good morning, Ms. Jones. I appreciate you coming in today and sharing with us. And want to just acknowledge just the progress that you've made since some of these initial events, and just want to acknowledge that it takes a lot of courage and it takes a lot of sort of perseverance to continue to move forward in the direction that you've moved. So thank you. I'm curious, on your application for early termination, it's dated in the year, you okay?
Yep.
All right. It's dated 2020, but I noticed that you did not put the 2017 offense with your sister on your application. Could you help the board understand why that is not there?
I am not quite sure what on my application.
So on your application for early termination, it asks you about all the different events and incidents that you've been in, and you mentioned the ones that happened earlier in your life, but you did not mention the one that happened in March of 2017. Right. So I'm just curious why you omitted that from your early termination request.
Well, I think what it asked is convictions, and it was dismissed. So I think that was part of the reason why it's not there. I don't know if I overanalyzed that question, but again, it was dismissed. And I, you know, again, the judge saw fit that it was deeper. There wasn't, some things were embellished, and it went a little too far on my sister's end. You know, she verbalized that she wanted to hurt me.
Ms. Jones, you answered the question, thank you. Okay. And I'm gonna slow you down just for the sake of brevity, just to sort of dovetail with what the judge asked. If you could just answer the question I asked, that would be really helpful for me.
Yes. Jonathan, if you can hear us, oh, okay, he logged out. Okay. Your Honor, maybe we should move to the next board member, and then if Jonathan is able to resume, we can continue.
We'll do that. All right. So that would be Christopher Jones.
Hi, everyone. I'm back.
Oh, okay. Mr. Jones, hold on. We were going to go on to the next questioner, but Mr. Maddox, I'm glad you're back. Go ahead and continue.
Which is completely appropriate. My computer was playing peekaboo. My next question is, so looking at your history of some of the offenses that you engaged in, what we know as therapists is that persistent alcohol use is really plugged into something from our past. And I know that you've been in therapy, at least since you've been on probation. But what I haven't heard you speak to is sort of what you've learned about where that alcohol use was plugged into in your past. So could you speak briefly to what you've learned about yourself that had contributed to your alcohol use? And I'll just preface it by saying this. We're not only looking at public safety, we're also looking at personal rehabilitation that moves beyond just doing activities that are required by the board. We actually like to hear sort of what you've learned about yourself and how you've identified and grown from the things that have been painful in your past. So could you briefly speak to some of those things to help us better understand how you personally have been rehabilitated?
Yeah, I mean, I think the alcohol has stemmed from my adoption. Oh, there's an echo. From the pain of just feeling abandoned, feeling a little confused. And also I mentioned being transracially adopted. And as we know in the current climate, race is a big thing. And so, and also I think just simply as a lot of human beings do, I learned to cope in a dysfunctional way, you know, and I was young and that was kind of my crutch. I think what I've learned is that I've come to terms with that I'm blessed. I've let go of kind of wanting to know the details of my past, who my parents are and my family, all those things. And I've learned just how to cope with my feelings and my pain differently. I've just grown. I've grown up. I'm almost 40. You know, when I was going through all these things, I was you know, younger and but I've learned it's important to seek support. I've learned it's important to talk about your problems, to have the humility to face your pain and your mistakes. I've learned so much, and I do feel like I've spoken to that a lot throughout this process. But I know it was deeply stemmed from my adoption, some relationships with men, and also family systems, family patterns. Again, family members still drink currently. So I was raised, like drinking was acceptable in my family. Like nobody smokes in my family. Nobody does drugs, but drinking was very acceptable. So I was also kind of conditioned. This is kind of what you do to escape. But I've learned that that is not the answer.
Okay, thank you. That's really helpful.
Awesome.
So are you familiar with the term white knuckling? I'm sorry, I didn't hear your answer.
There's a little bit of a delay. So I just heard the question.
Yeah. No, my question was, I'm sorry, my question was, are you familiar with the term of white knuckling?
Definitely. I think when 2004 to 2005, I white knuckled, 2005 to 2008, I white knuckled. I think I mentioned earlier that I was young and I stopped drinking on my own accord, on my own strength. And I think that's like the epitome of white knuckling, is when you knuckle through and you just do it. Now I've realized that it's a transformative process that sometimes takes time. And it's not just about the behavior, it's about your heart. I really believe that I've been through like a spiritual transformation as well. So definitely aware of the term, and I used to do that.
Okay, great. Thank you. Could you speak a little bit to what does your support system look like now?
So as I mentioned, my parents are very present. I know they love me. They have their own issues with things, but they are very supportive with you know, my growth. I have 4 siblings, and you know, 2 of them are supportive. I have a couple friends that are very supportive, and I have also a couple colleagues that are very supportive. So I have a strong support system. I have my faith, I have my church, I have my godmother. So I have a lot of people that support me, and I also have a significant other.
Excuse me, I just real quick, I'm sorry to interject here. If any,
I'm sorry, Judge, I can't hear it. There's too much of a delay. Shall we go off the record, Judge?
Please make sure that all your devices on stuff might be on screen and interference.
Yeah, let's go off the record. Right now, this is Judge DeCure. I think that we have to make sure that anybody who's not speaking has their microphone muted, because we're starting to have transmission problems, and to make a record, we can't have that. So just make sure your mics are muted for starters, and we'll go from there.
It's Jenny P who keeps coming up. It's Jenny P. She needs to mute her audio.
Right, I keep seeing her as the dominant person on my screen as well.
So Jenny P, please, if you are using your phone, also mute that.
Right. Often when you're using two different devices, like you've got your mic on your phone open and you've got your mic on your computer, it causes feedback, and I've been hearing feedback as well. All right, I don't hear anything now. So Mr. Court Reporter, Mr. Sanjeev, let's go back on the record and continue if Mr. Maddox has any further questions.
Yes, I actually do. So Ms. Jones, so one of the things that I'm hearing, and it may just be unique to me, is that I wouldn't call them excuses. You seem to have a lot of rationales for certain decisions that you've made.
I'm sorry, this is a court reporter. We're going to go off the record again. I apologize, Judge.
All right, we're off the record. I did not hear your question, Mr. Maddox. It was all broken up on my end.
Can you hear me now?
Yes.
Okay. Ready to
All
go.
right, back on the record. Go ahead.
Thank you. And I apologize for all the challenges. This virtual world is interesting. So Ms. Jones, so one of the things that I'm hearing, and I wouldn't call them excuses, but you tend to have a rationale for a lot of the choices that you've made in your past. And I hear less taking responsibility for the individual acts that you have committed. What role does what role have you learned about personal responsibility? You take personal responsibility as your own.
This is a court reporter. We're going off again.
Public safety.
All right, this is Judge DeCure. We're off the record again. Mr. Maddox, your questions start off well and then tend to break up terribly. I don't know what's going on.
I think I picked up on what he was asking.
Well, we're off the record, so I just want you to be patient.
So Judge, so here's what I'm going to do. I'm going to change my device. Why don't you move on to the next person? And then after they go, maybe you could get back to me. I'm going to get another device.
All right. Thank you, Mr. Maddox. So we're back on the record and we'll hold Mr. Maddox's place for further questions if he has them. Let's move on to Mr. Jones.
I have no questions at this time.
All right. Thank you. Ms. Friedman. Susan Friedman, you may have your mic muted right now.
Can you hear me now?
Yes.
Thank you so much, Ms. Jones, for being here and for sharing your life story. I understand that maturity, of course, changes things. It's changed things for all of us. I mean, all of us understand as you become more mature, what happens. You lose those parts of your life that didn't make much sense when they happened. One thing that I'm curious about is you've mentioned a couple of times the importance of your family, and you've also mentioned the pressure of certain other things. There was pressure on you from certain other things. And I'm just wondering, when you're with your family and your family does drink, how do they respect your attempted sobriety, and do you feel totally comfortable not drinking at all when you were with them, because they're a very important part of your life?
Thank you for your kind words. And yes, I do feel comfortable around them, but I do, the more I move through this process, I realize that I need to have boundaries. And you know, if it's 9 o'clock at night and everybody's drinking, I tend to leave by 7. You know, I just, you know, I really believe it's also a spiritual issue. So it's complex. And so my spirit just wants to be safe. It wants to be around things that uplift me and nurture me. Yes, my parents do respect my sobriety, yet I think my family, they have their own addictive struggles, right? And so I don't think they fully can comprehend at times what I need, but that's my responsibility. And I see that more clearly now, that I need to connect to what I need and to protect myself and to protect this process. And so I really don't hang out with a lot of people who drink. My friends don't drink very much. I'm trying to go down a different path. I think we all know that family can be triggering. Drinking aside, family can be interesting. So I connect with them when it's safe, and I do my best to, when, if they are drinking, to remove myself, and just to support the path that I'm on.
Thank you very much.
Of course.
That's all I have, Judge.
Thank you.
Thank you very much. Mr. Ehrlich, do you have any questions?
I have no questions at this time. Thank you, Your Honor.
All right, thank you. Deborah Brown, do you have any questions?
No, I have no questions at this time.
Thank you. Dr. Brew, do you have any questions?
Yes, thank you so much. And thank you, Ms. Jones, for coming in. I want to acknowledge how much you have grown and matured in this amount of time in your life. And I also, this may speak to a little bit about what Jonathan was getting to. I hear about the maturity piece and just making bad decisions. I hear about how helpful your faith is. But what I'm not seeing is some healing in you. Like even the amount of shame you still carry about your past, like there's a part of you that's transcended it in terms of making meaning out of it and helping it forge your path to come into this profession and do this really important work. That, as you know, as healers, we have to be, let's say, healthier than our clients, maybe not our healthiest selves. And I'm not hearing that healing piece. It's and it may be family of origin stuff. It may also be as a woman of color living in a very white world, at least when I see where addresses are of where things have happened, and a lot of racial trauma that I would imagine has happened. So I guess what I want to hear to feel like you're safe to practice is healing and something different than what you've said before, something more than religion, something more than maturity, something about more than I just make better decisions.
That's interesting because I think that this process has been the difficult piece, or maybe even where you're picking up on shame, is I think the interesting piece about when your personal and your professional collide, right? And I think that's been something that's been interesting for me to navigate because I have worked so hard and I want to have, a solid professional name. And so I think that sometimes that has been tricky for me, right? Like even that self-disclosure piece, as therapists, that's not always appropriate. But in this process, I have to self-disclose everything. And so I don't know if I agree with fully shame. I think that this has been a painful process. And I've had to relive it over and over and over and over and over and over again. And I think for anybody, that would be hard. In regards to telling you something different, I feel like I've said a lot.
If there's not more, that's fine.
Excuse me, this is Judge Shakir. Just in total fairness, I know Dr. Brew's not an attorney. What attorneys typically are constrained to do when you do cross-examination is ask questions. And as I said, in fairness to Dr. Brew, I didn't really hear a question. I heard sort of a yearning to hear more. And the way I would boil it down as a lawyer to a question that perhaps you can answer is, do you have anything additional to say about whatever healing has occurred in you? And I hope that's accurate, Dr. Brew, as a question.
Sure. Fine. Right. Yes. As a therapist, I think like a therapist, not a lawyer. That asks the question. Thank you.
All right. Thank you. So do your best to answer that question, Ms. Jones.
Gosh, I feel like so much healing has taken place. It's hard to know where to begin. I do believe I've healed from, you know, when I was younger, I wanted to know my birth parents and wanted to know every little detail and wanted to understand. And now I think I'm actually being protected from that piece. And I've been given such a blessed life with parents who love me and have been married since they were 19 and they're still together. And so I've healed in that capacity, that I don't yearn for answers. I don't yearn to know everything. I've also healed in the fact that I don't have a desire to drink and I don't want to. I think 5 years ago, I would have thought, oh, it would have been nice to have a glass of wine with my husband one day, or, oh, that would have been, I don't feel that way anymore. I know I do not need a substance to make myself feel complete. And I think that is profound healing. My sister, you know, she has betrayed me a lot in my life. And as you read in her letter, I've been there for her.
We're sorry. Your conference is ending now. Please hang up.
What?
This is a reporter. We're going off the record.
Yeah, off the record. I just heard that, and this is Judge Akira. I'm hoping our administrator can tell us that this is going to be okay.
No, that I believe was coming from someone else. It's not coming from us. So.
Okay, we may have lost someone, and if that's the case, based on time, we've got to just keep going. But we're going to. I know typically in these hearings you like to go to the end of the hearing. We're going to have to give the court reporter a break at some point soon. I want to try to do our best to press through, but I don't want it to be a marathon, since I know he's typing as fast as he can. So it sounds like somebody's reconnecting. All right, let's go back on the record and continue. Ms. Jones, you were finishing your answer on healing.
I lost where I was. My sister, there's been a lot of betrayal. And as you guys have read in the record, the letter that she wrote, I've been very supportive and very loving towards her. And I've learned to forgive her. But my emotion is because I'm just a sensitive soul and I feel deeply. And I also believe the Spirit of God helps me feel deeply. But I've forgiven her. I have a great relationship with her daughter, my niece. And, you know, she has hurt me a lot in my life. But I forgive her and I continue to show up for her. I think that's been profound healing. Even coming here today, you know, facing you guys, and I didn't have to do this. Like, this hearing was requested. I didn't have to come here and tell everybody all these things and have this on public record forever. But I think I faced my shame, and I've healed in a lot of ways that I'm more humble, and take accountability for what I've been through. So I've healed in regards to addiction. I don't feel like I don't use any substances. I'm not on any prescribed medications. I barely even use Tylenol. I'm proud of that I work through my pain, whether physical, emotional. I've healed relationally. I've healed professionally. I mean, the 2 letters that you guys received are from the owner of my company and my direct boss. And they know everything that I've been through and they support me fully. And I've cultivated meaningful relationships with one of my colleagues. So I think I've healed in a lot of respects. So yeah.
Yeah, thank you.
Yeah.
Just a quick yes/no question.
Sure.
Would
I struggle with that.
Would you say that when you everything related to the convictions or any police involvement was correlated with, except for the one-time driving without a license, was all correlated with alcohol use?
Mostly, I would say the one with my sister was more relationship based.
Okay, that was the only one that's not.
You know, the other ones I was intoxicated, you know, and not really intoxicated. I think, as Anita mentioned, my blood alcohol levels and stuff. With my sister, it was deeper and more complex. But yes, I mean, alcohol has been the reason why I have been in the legal system.
Okay. So the again, a yes/no question.
Sure.
The whatever wounding that was happening between you and your sister in that conflict, that has healed.
You know, I think it's best as it can for what's happened throughout our relationship. So yes. Yeah.
Thank you. I really appreciate it.
Yeah, thank you.
All right, thank you, Dr. Brew. Crystal Anthony, do you have any questions?
I have no questions.
All right, thank you. And we're down to the chairman, Mr. Disposti. Do you have any questions?
No question, Ms. Jones. Thank you for being here. Just a clarification. I know we talk about early termination, but in looking at the petitioner application, there was always also the possibility for early termination and or modification of the probation. I just wanted to make sure for the record that we all knew it kept in consideration. Am I correct?
I believe so. Yes, I would love early termination, you know, ultimately, but I think, are you saying early termination or a modification?
The application came through as a request for early termination and or modification of probation, one or. Of course, you expressed your interest, and that's totally legit. I just wanted to make sure for the record because it never came up in the conversation, Your Honor. So that's just for the record.
Oh.
Hey, this is Judge DeCure, Ms. Jones, and what I'm going to do at the end of each hearing is allow a couple of minutes of closing remarks for each petitioner and for our Deputy Attorney General, whose perspective I think is important to the board. We'll table that, but we will get back to that quickly. I know that there is another board member who was not done asking questions when he got disconnected or had audio trouble. Mr. Maddox, do you have any more questions?
Actually, no, I've heard sufficiently from Ms. Jones, so thank you for your time today.
All right. Thank you very much, Mr. Maddox. Okay, what we're down to now is redirect. And actually, I think based on the length of the answers that you gave and the fact that the board members and also our Deputy Attorney General were very generous in allowing you to answer questions as broadly as possible, I'm going to move on from redirect testimony. What we're really down to now is closing statements, and it is 10:27 in the morning. I'd like to finish this case before we go off the record and start with another one because I know we have 4 more. So, Ms. Jones, you have talked a lot this morning about your position. You appear to have been very candid. I don't want you to reiterate any of the basic background points that you've made, but this perhaps is a good time for you to encapsulate for the board what it is you're asking for, because I think that was a good point that Mr. Disposti, the chair, just made. So with that, take about 3 minutes to give your closing remarks, and then we'll hear from the Deputy Attorney General. Thank you.
Yeah, I think what I'm asking for is early termination, which would be a reduction. You know, I do believe I have taken personal responsibility. I think around the issue with my sister and the gentleman, I think it's important to understand that those were hurtful relationships that I was involved in, to put it into context. But my intention was not to dismiss my own accountability and responsibility in those circumstances. And I just want to make that clear. You know, the DUIs, I've taken full accountability. I was there, I was alone, I was by myself. But the other 2 issues, there were people involved that crossed boundaries and did hurtful things. And so I think it's just important to understand the context of that. I just really appreciate your time today. I know that I've had a lot to say. You know, I'm a woman of words, I'm a writer. I have a lot in my heart, and so I do appreciate you listening. I know I've taken up some time, but I hope that you guys can feel my heart in this process and feel my intentions. I've done everything that the board has asked me to do and beyond. I've done everything legally that I am supposed to do and beyond. And as you saw in my petition packet, I am on the IADEP board. I am a leader at my job. I am in management positions. I have published a book. You know, I am multifaceted in this process to try to be a better person and clinician. I have grown a lot. And, you know, the major message is I don't feel I deserve to be on probation when I'm licensed due to just the length of time where the majority of my issues happened. And so I hope that you guys take that into consideration. I totally understand being on probation as an associate and getting hours, but I do feel like I have proven through the owner and my bosses and all my letter of recommendations that not only am I fit to counsel and I'm safe for the public, but I've been constantly promoted because they have experienced me to do so. So I hope that you all take that into consideration, and thank you so much for your time.
And this is Judge DeCure. Thank you very much, Ms. Jones. Ms. Crawford, please go ahead and make your closing remarks.
Thank you, Your Honor. As the board and Your Honor is aware, for petitions for early termination of probation, it is the petitioner that bears the substantial burden of demonstrating rehabilitation and current fitness. And the criteria is listed within the Code of Regulations. It involves considering the nature and severity of the acts and the crimes. It involves looking at subsequent acts since the individual was convicted. It involves looking at the time that has lapsed since those criminal convictions and the efforts that have been made by the petitioner to rehabilitate. And in this instance, the petitioner has been very forthcoming and honest about her convictions. There was alcohol use that escalated in criminal convictions between 2004 and 2008. Those were for high blood alcohol levels, 0.12, 0.13, and they involved 18 months of rehabilitation courses that she was to undergo. Regardless of those courses, the petitioner did continue to use alcohol, which would demonstrate that there was a serious alcohol problem. She has now indicated she's been sober for approximately 3.5 years. That is certainly with the assistance of the board's probation program, which she has been on for 2.5 years. And the board is in the position of considering whether at this point, with 2.5 years remaining on her probation, if the petitioner has sufficiently rehabilitated that her probation should be terminated. Submitted, Your Honor.
All right, thank you very much. Thank you, Ms. Jones. We're at the end of the hearing. I'm going to close the record, and the board will be deliberating later today on your case. So we're off the record.
Thank you, Your Honor. So it's 10:33. We can reconvene at 10:45. I really would like to make an appeal to my colleagues and the future petitioners. I know they were all we want to offer the same time to everyone is here, but at this pace, we will not be able to hear everyone because we have 4 petitioners to go in the closed session. So I invite you to be very aware of the time. Again, I don't want to limit anyone's expression, but even for our petitioners, we invite you to be very specific about the narrative and the questions you're asking, because on this trend, we will not be able to conclude the meeting today. So I'm really concerned. So I leave you with that. So hopefully you take a restorative break, and we will hear so that the next petitioner can be ready will be Julian Laurie Nicolason. I'm so sorry. I hope I didn't mess up the name, but Nicolason will be the next petitioner to be here when we re-adjourn at 10:45. Thank you so much. Please stop your videos and mute yourself. Thank you. August 14, 2020, and it's 10:46 a.m. Your Honor, you can proceed. Thank you.
Thank you. I'm opening the record in the matter of the Board of Behavioral Sciences, a petition for modification or early termination of probation, which was filed by Julan, Julann, Lori, Laurie, Nicolaisen, Nickolaisen. I'm an Administrative Law Judge John DeCure. Today is Thursday, August 13th, 2020. It's approximately 10:45 in the morning. And this matter is being heard telephonically due to the national health crisis, and it is before a quorum of the board, and actually all board members are present for the hearing. The agency case number is 2002-015-00-1619. The Office of Administrative Hearings case number is 2020-070-586. May I have an appearance, please, by the Deputy Attorney General? Ms. Crawford?
Sorry about that. Let me repeat myself, unmuted. Anahita Crawford, Deputy Attorney General, appearing on behalf of the Attorney General's office.
All right, thank you very much. Ms. Nicolaisen, are you on the line? Okay,
Yes.
Ms.
Oh, wait, sorry. Yes, I'm here.
All right. Keep in mind that you're going to have to keep your mic muted whenever you're not talking. And there may be times just like that where you think you're talking and being heard and your mic is muted. So just keep an eye on it and we'll do fine. First of all, are you representing yourself in today's proceeding?
Yes, I am.
Okay. You do have the ability to have a lawyer represent you in a hearing like this. Do you understand that?
Yes.
Okay. If you choose to represent yourself, the biggest difference in the hearing is that you'll be giving testimony without a lawyer asking you questions. So it will be a narrative statement. And then you would be subject to cross-examination from the Deputy Attorney General and the board members. Do you intend to testify on your behalf today?
Yes.
Okay. Please raise your right hand. Do you solemnly swear or affirm that in the testimony you're about to give in this proceeding, you'll tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, thank you very much. What we're going to do this morning is I'll start with the Deputy Attorney General, Ms. Crawford. She's going to identify the exhibits that have been entered, not yet entered into evidence. I'm going to mark them and I'll ask you if you have any objections, but I doubt that you will since most of them were provided by you. But we'll get through the documents so that we know what record the board is actually looking at in terms of physical documents. I'm going to ask Ms. Crawford to make an opening statement. And rather than you making an opening statement, I'm going to allow you simply to testify. And when we get to that point, I'll give you a couple of very brief suggestions as to how you can proceed. And we'll go from there. So I'd like to begin with Ms. Crawford and the documents.
Thank you, Your Honor. Our documents, there are 5 exhibits. The first exhibit is the board memo regarding the probation status of the petitioner. The second is the notification of hearing for today's hearing date. The third is the certification of registration history. Fourth is the petition for early termination of probation and the attachments and support. And the fifth is the stipulated settlement and disciplinary order along with the underlying accusation. I would like to have all of those marked 1 through 5 and admitted at this time.
All right, this is Judge Secure, finally unmuting my mic. And I have marked exhibits 1 through 5, which were just identified by Ms. Crawford on the record. Ms. Nicolaisen, do you have any objection to those exhibits being admitted into evidence?
No.
All right, there being no objection, exhibits 1 through 5 are admitted in evidence. Ms. Crawford is going to make her opening remarks, explain who she is and how she is a part of this proceeding, and then we will get to your testimony. So, Ms. Crawford, go ahead.
Thank you. This is Anahita Crawford, Deputy Attorney General, appearing on behalf of the state of California pursuant to Code Section 11522. I am here to assist the panel in fact-finding. My role is not adversarial, but intended to ensure the panel has adequate information from which to make a decision and to protect the public interest. By way of a background, the petitioner was issued a licensed clinical social worker license on November 19th, 1989. The board filed an accusation on January 25th, 2017. Pursuant to a stipulated settlement, the petitioner's license was revoked on March 22nd, 2018. However, that revocation was stayed and the license placed on 3 years probation. 7 months remain on petitioner's probation period. In the accusation, the petitioner was charged with incompetence, gross negligence, and failure to maintain confidentiality. It was based on acts that occurred in 2012 when the petitioner had provided 17 therapy sessions to a client, SS, and 4 to his wife, JG, in relation to a dissolution proceeding. In 2014, the petitioner submitted a letter to the Superior Court expressing her professional opinion that custody of the couple's children should be with their mother, JG, and that her opinion was based on having provided extensive counseling with the family. In submitting her letter to the court, the petitioner did so without authorization from SS, exaggerated her involvement with the family, expressed an opinion about the placement of the children, but showed no involvement with their counseling, submitted a biased letter to the court, and by doing so, failed to maintain the confidentiality of SS. As part of her probation, petitioner was required to obtain education units, pay cost recovery, and comply with standard terms and conditions. She is in compliance in all aspects of her probation. Thank you, Your Honor.
Thank you. Ms. Nicolaisen, when you testify with a lawyer representing you, the attorney would ask you questions to draw out your testimony. It's essentially your opportunity to tell your story to the board. Since you don't have somebody here to ask you questions, I'm going to allow you on the first portion of your testimony, which is what we call direct examination, to give a narrative statement. My one suggestion for you is that probably it will go most quickly and efficiently for you, which means you won't leave holes or gaps in your testimony that you would regret later if you perhaps would go chronologically. Now, it's up to you how you want to testify, but that's a generic suggestion that I make to keep most witnesses who have to give a narrative statement without the help or prompting of a professional asking questions, to make sure you do it as thoroughly as you can and cover all the points you want to cover. That being said, if you do hear Ms. Crawford make an objection, you'd hear the word objection and just stop testifying, and I'll deal with the objection and we'll get back to it. That may or may not happen, but that's Ms. Crawford's prerogative. So that being said, go ahead and give your direct testimony now. Thank you.
Okay. I appreciate your time and consideration this morning. I've been in private practice for over 30 years and have worked, volunteered a lot in the community. I've been a very upstanding citizen. Did get caught up in a very contentious custody situation. At the time I saw the couple, they were trying to work on their marriage. And then I was contacted by the court mediator to get information about custody. That was 5 years later. And was not able to connect with him. And so I did write a letter. I did have a release to speak with the court mediator. I did write a letter. I addressed it to whom it may concern. I mistakenly thought that that release covered that letter. That was not so, and I regret that I was not more careful. And I was also accused of having a dual relationship, being friends with the wife, which is not true. I am part of a large religious community, which is, so everyone knows everyone. That doesn't make us friends. He claimed that we were friends. I certainly knew who she was. She knew who I was. At the time that I saw them, they had moved to a different city. I have never spoken to her on the phone, never gone to lunch or dinner, a movie, never interacted with her in any way socially. Nonetheless, I took my poison and I went through 30 hours of law and ethics, which was very helpful, and 30 hours on dual relationships, which was a very intensive group therapy-like experience. I found both of those to be helpful in me being more careful and more detailed in how I handle forms. And if I have questions about legal situations, I now confer with an attorney. I get feedback from colleagues. And I have tried in every way possible to be as professional as possible. This has been a very humiliating experience for me, because I've tried my best to be an excellent social worker. I feel like I've helped a lot of people, and I made a mistake. I wasn't careful, and I feel like I have paid a price, literally and financially. In terms of my profession, in terms of finances, I've paid a price, and I will never again write any letters or express opinions. And I feel like the things that happened were exaggerated in how it was expressed, but nonetheless, I've done what I've been asked to do, and I would love to get back to clear. I would love to have my name cleared and continue to practice for at least 5 more years. I'm getting ready to retire. Just want to get my last, I have 5 kids, I'd like to get my last kid through college. That's it. That's succinct. And,
all right, thank you. This is Judge DeCure. And by the way, I know this is the most difficult for you because the hearing is about you and your past experiences and your professional life, etc. So if you need to take a break, please just let us know. Okay.
I'm okay.
All right.
I also like to mention I did go back into therapy briefly to work through some issues. And anyway.
You want to talk further about that?
No, that's unless people have questions.
Okay. The questions, I want you to really focus on this because we, at our previous hearing, we had questions and often the answers from the petitioner were very broad to the point where I think she went beyond answering the questions. It was unintentional, but it consumed a lot of time. And typically in a legal proceeding, which this is, even though it's before lay people board members, we've got a deputy attorney general attached to it. I have to make a record as a judge. And so what I want you to focus on is this. Take the pressure off of yourself. First of all, you don't have to give an expansive answer that covers every last point you can think of. This is not a job interview, okay? If you're asked a question, listen carefully to that question. Think about that question only and give your best answer to that question. Then just stop, take a deep breath, relax, and wait for the next question. I think the Q&A process goes a lot better if we can just do that. And I'm going to ask the board members also, when you're asking questions, please try to ask an actual question rather than make a statement, because that makes it very difficult for the petitioner when she can't quite hear or discern the question. That being said, I'm going to move first to Ms. Crawford, because I know she's a trained attorney and she will get all of us oriented to the question and answer process quite well. Go ahead.
Thank you, Your Honor. Good morning, Ms. Nicolaisian. You have been practicing since 1989, and that was about 15 years into your practice when this situation arose. Have you looked back and considered why you made this error in judgment in this case when at the time you should have presumably been comfortable with the nuances of your practice and ethical obligations?
Absolutely. That's an excellent question. I've thought about it a lot. I feel that I allowed myself to get too caught up in the emotion of it, I think, and didn't have the right boundaries. I had the feeling I shouldn't write the letter, but I went ahead and wrote it anyway. And looking back, I think sometimes when you've practiced for a while, you maybe get a little lax. And I think this experience really helped me tighten up how I practice.
What motivated you to write the letter at the time?
I was frustrated that I hadn't been able to get in contact with the mediator because I knew I was one of the main people that had worked with the couple, and I felt like it. And again, this was my personal feeling, which I shouldn't have cared about that, but that I felt like it would be egregious to not have my feedback in their consideration. Although actually we ended up getting copies of the meeting they had, the judge with the attorneys, and they threw out my letter. They didn't even use my letter. So it didn't affect the custody at all.
Okay. And you've explained why you wrote the letter in order to have your feedback be considered, possibly. Why did you choose to express the opinions you did in the letter?
Yeah, I feel like it was mischaracterized. What I said in the letter was that I felt like at the time the mother had primary physical custody because they were little children. I didn't say the dad shouldn't be involved. I did know some other things about the dad that weren't, and I didn't mention them in the letter, but he had a history of substance abuse. He had been driving with the kids under the influence in the car. I felt like he wasn't in a good place. I didn't want to throw him under the bus and include all that. I just made the statement that given, at that time in their lives, I come from a large family. I've worked a lot I have 5 children of my own. I think I know a lot about child development. I have the bias that their primary attachment was with the mom. He was a workaholic. He owned his own business. He had nothing to do with the kids by his own admission until the wife threatened to leave him. And only then did he become interested, and it felt like it was more in reaction to her than out of caring for the children.
In your own therapy, have you discussed what led to your motivation to write this letter and what to do in similar circumstances so that you wouldn't end up here again?
Yeah, absolutely. I need to have better boundaries, not take on too much responsibility. I felt like I was probably a little codependent in that situation. Yes, that was a major focus of the therapy. What made me vulnerable to that mistake.
Mm-hmm. And when were you involved in that therapy?
That was 5 years ago, right when I got the letter. So I got the letter about the complaint exactly 5 years ago. And so after that, I saw a therapist for probably 6 months.
Okay. And do you continue in any kind of therapy now
No.
that you receive?
No.
Okay. Since being placed on probation, have you come across any situations where you've identified a potential conflict or a similar issue, and how have you handled it?
Yes, I have a case right now, and I just let them know up front I am not going to get involved in the custody stuff. I will work with your little daughter and work on her depression, but I will not write any letters for you. I will not get involved in the custody stuff. I state that up front, and I've also stated that in the forms that I give them when they enter treatment with me, so that it's clearly the expectations are up front of what I can do for them.
What have you learned during your probation period that you can share with us that'll assist you in not repeating the conduct that is alleged in that is contained in the accusation?
I think it's as a therapist really good to stay humble. I think it's really good that we have ongoing requirements to review law and ethics that keeps us focused, because I think naturally we can flow away from dotting all the I's and crossing all the T's. And I think I reflect on this frequently and will evaluate what I'm doing and try to be more careful in whatever I'm doing. Anyway.
Thank you. I don't have any further questions.
Thank you very much, Ms. Crawford. So to keep it interesting and fresh, we're going to change up the list and start with our chair asking any questions he may have. Mr. Disposti.
Thank you. I knew you were going to do that.
I lost the power to surprise you already. Sorry.
It's all good. Thank you to the Deputy Attorney General, because the questions were very helpful. My questions, Ms. Nicolaisen, thank you for being here today and for being so patient. I see that the probation is ending in March 2021. Am I right? Something around there. So why now?
Is that a yes? I'm sorry.
Yeah.
Yes.
Okay.
Sorry. Yes.
I apologize for the interruption, sir.
No, it's okay. I also override her too fast. So I just was wondering if you can speak a little bit more about why asking for the early termination now. I know the process sometimes takes some time. We're already in August, and I don't mean to undermine that every month it's a heavy weight for you. But if you can speak a little bit to that, since we're really almost less than 6 months away from the end of the probation.
Yeah, a good question. My probation analyst recommended I apply for early termination when I first met with her. And she said once 2 years was up, I would be eligible. So in February, that's when I started the process, but it's taken till now for it to happen.
Correct. And just for the record, you are entitled to do that. It wasn't questioning the action. Most about what has meant to you to have the probation in place. I know you had to disclose, obviously, the probation to the people you're working with, and if you can speak a little bit to that in relations to the time that's left from here to March as well.
For sure. I think, I had to drop off some panels that I was on because I had an action against my license. So I couldn't be a Blue Shield provider anymore. I couldn't apply for some other positions because of the action. I felt like I couldn't move. So I felt trapped in decisions that I could make for my life. And I'd like to lift that.
Thank you. Thank you for answering that. And no further question, Your Honor. I'm okay.
Thank you. This is Judge DeCure. Let's move on to Ms. Anthony. Do you have any questions?
I have like a comment and maybe a question, so sorry. So I just want to thank you for being here today. And I just want to, I feel like I always pick one person during these hearings where I feel like they need to hear this, but you are way more like than your worst mistake. This doesn't define you. And I feel like there's a lot of shame that comes when you get in trouble with your license and things like that. But I admire the fact how remorseful you are, and how the fact that you are so open with us in regards to, and very authentic about what happened and things like that. So I guess my only question is to me, this is just a question. like you can put on your board, like you're not going to write a report for court, but court can order you to write a report. Like a court, you can get a court order for a report and you'll have to submit that. So what would be like the steps you would take now in order to make sure that you are crossing all your, like dotting all your, you know, the saying, crossing the dots, lines, all that. So you're making sure that you have everything that you need. And this wouldn't happen again.
I for sure would not just leave it up to my own opinion, but I would check with an attorney and or consult with colleagues that have maybe, you know, I don't do a lot of custody work. Definitely after that experience, I really try to avoid it because it's just naturally messy and involves legal stuff, right? So, but if I am exposed to that, I plan to do more consulting to get feedback about how to proceed and not make an emotional choice.
Thank you.
Ms. Anthony, are you done with your questions?
Yes.
All right, thank you. Dr. Brew, do you have any questions?
I don't have any questions. Thank you for coming.
Thank you. I'm sorry, I just promoted Deborah Brown to Dr. Dr. Brown.
I don't have any questions right now.
All right, thank you. Ross Ehrlich.
I also do not have any questions at this time. Thank you, Your Honor.
Thank you. Susan Friedman, do you have any questions?
Just want to say thank you very much for being here and sharing your story with us. I have no questions.
Thank you. Christopher Jones, any questions, please?
No, I have no questions.
All right. Jonathan Maddox.
No, I have no questions, but I do want to say thank you for coming today. The one question I did have, you did answer, and I'm glad to hear that one of the things that you've learned throughout this process is that you're willing to consult and collaborate with colleagues to sort of get advice to direct choices. Because I'm assuming you were in private practice, and I've done that, and that can be very isolating. And so sometimes you are put in a position to make decisions without the consultation of others. So I'm really glad to hear that. So thank you for coming, and I have no questions.
Thank you. Mr. Ranasinger, do you have any questions?
Yes, hello. Ms. Nicolaisen, I'm actually not a clinician. I'm a child welfare attorney. Did the court mediator know that you were providing, you had provided therapy to both parties when he asked you for a letter?
I believe so.
Okay. That's all. Thank you very much. And thank you for being here.
Thank you. Mr. Sobek, do you have any questions?
I do. Thank you very much. And before I begin, I just want to confirm with you, what are the pronouns I should address you with?
She.
Thank you. So I have a little bit of a question. I noticed in your application, it talks about that you saw JG for individual therapy on approximately 4 occasions, and that you saw SS for individual therapy between April and August 2012. Is that correct?
Yes.
Okay. Because one thing, who would you call the unit of treatment then while you were working with them?
Well, I think initially I would have called the JG, my identified patient. And the reason SS wanted to work with me is because he knew I had worked with her. And maybe one idea would have been to refer him to someone else.
Okay. Because, and I want to ask you this is just to help me clarify this next question. Your opening statement today was something you had prepared and had a chance to write down?
I was unaware of how this would proceed. So no, I didn't have it written down or prepared prior to today.
Okay. So I'm going to allow you a little leeway with this because I know this is very anxiety producing. But throughout your testimony, you've still been referring to them as the couple that you were seeing. And I'm intrigued by, after all of the work that you have been doing with your education, that even at this point in this work, you were still identifying the couple as your unit of treatment when you talk about them. Could you help me understand that kind of discrepancy that I'm hearing?
At the time they were married. So that's probably how I still see them. That's an interesting point. So when I worked with each of them individually, they were still legally married. So technically still a couple. They are now divorced. And so, right, but I haven't worked with them since they've been divorced.
And at no time did you actually see them together as a couple, correct?
Correct.
Okay. And then a little bit of a left turn, just go with me for a second. I know that when Jonathan Maddox was asking you a question earlier, in his statement, he identified you're an individual practice. Is that correct?
I'm a solo practitioner now, and I was at the time. There have been times I've been part of a group, but that was probably 20 years ago.
So talking about your current practice now, do you have a regular and ongoing consultation group?
I do not.
Okay. Thank you so much. That's all the questions I have.
Thank you, Mr. Sovek. Our next questioner may be Wendy Strack. Do you have any questions, Ms. Strack?
I don't have any questions at this time. Thank you for being here.
All right, thank you. Christina Wong, do you have any questions?
Yes. So just a couple probably question. So I just want to clarify the record for one. I think Ms. Crawford said that Ms. Nicolaisen? Mr. Nicolaisen, thank you. I like to at least
it's Danish, yeah.
Yes, address you accurately. So Mr. Nicolaisen has 15 years of license experience. I think actually Mr. Leisen has 30 years, of licensed experience. And so, I'm hearing your testimony, and I can really feel that how this process really create a lot of emotional turmoil and also the financial impact. And so I totally understand how much it really affected your family when you have 5 kids and needed to send them to college. And so when I'm hearing, look at your, on the paper, on the record, and also your verbal testimony, it seems to me that, the confidentiality, writing the letter was just kind of more on the surface. As a clinician and you're on the private practice, I think the biggest minefield seems to me that it is about, the emotional involvement.
Yeah.
Like you say, you get, it get too hung up, siding with the client. And so, now for that, that all these terms and conditions, it's kind of like just scratching the surface. So I want to hear from you that, how can you assure the board that, that emotional involvement, not getting hung up, it's not, it's going to be addressed, and, and also that you can monitor it and, that ensure the board that you're safe to practice in that sense.
For sure. I think that experience was very crystallizing for me. And I think it really has taught me that I need to, like I said, have very clear boundaries of my roles with clients. And yeah, I practice differently now than I used to, for sure, in many ways. Well, actually, what my concern now would be maybe sometimes too detached, but trying to find that right balance of caring, but also boundaries and professionalism.
Right. So now I have kind of like maybe a harsh, comment. So the boundaries and the professionalism, is what you learn, in your, the 30 years of practice, and every 2 years you have to take that law and ethics. Yeah. What makes a difference now? Because, you heard it at least 15 times of the renewal.
Well, I think you can look at my 30 years. I haven't had any other complaints filed against me. And so I made a mistake. I don't think you need to define my whole practice or my standing as a social worker by that one mistake, because I've done a lot of good throughout Southern California, not even just in my community. I've spoken, taught classes all over. and all for free. So I feel like it was out of proportion to the event.
Right. So I understand that, that the mistake, because of the magnitude of this, effect. And of course, we can choose to look at, all the years that, you have done, and all the wonderful work that you have done, which I have no doubt. And I think for me, the most important thing is like, because especially you are in private practice. And, Mr. Solveig actually did mention the very important thing is like you are practicing alone. And so and you have basically not much people to hold you accountable. And so, and the emotional involvement, AKA the counter transference, it happens so easy. Yeah. And so what I'm really asking you is that, because we do have a mechanism in place, and yet I think, it's really about like in the future, that finding the balance, like you say, is hard. But again, I think it's important also, to have the board, to hear that, the mechanism you have in place, that how can you really get yourself in, how can you monitor yourself?
Yeah,
so
I don't belong to a formal group that consults, but two of my good friends right now are therapists, one in Diamond Bar, one in Moore Park. And I do talk with them now because I feel that loneliness. And so we do talk about cases, but it's not a formal official setting.
Right. Okay.
But I stay on top of my continuing education. I do extra reading outside of that. Anyway, I do things to try to keep myself healthy so that I can be the very best therapist for my clients.
Absolutely. Sometimes, the devil is really, like you say, get too lax. Right. Yeah. So I think having something to, to really continue to hold yourself accountable, to really keep yourself in check is really important. So I know that, you probably don't have a formal mechanism in place, and I do encourage you, to seek the professional support, outside just, outside your practice. I think it's actually really, really wonderful. And sometimes when we have difficult clients and they really just kind of like, at the end of the day, it's really, really difficult, to balance your professional and your personal life. So I do encourage you to take some serious consideration about that.
Yeah, that's a good suggestion.
Thank you very much. I have no further question, Your Honor.
All right, thank you very much, Ms. Wong. Okay, Ms. Nicolaisen. I'm sorry, I mispronounced your name before now, but I'm glad I know it. The really excellent suggestion that the previous petitioner was given during a hearing by our chairperson at this point was really to, typically in these hearings, I allow the parties to make closing remarks that will help orient the board members once they've heard and seen the evidence. And so we have heard your testimony and you've answered questions at length now. So this is your opportunity to, I think, tell the board what you'd like the board to do and why. All right, go right ahead.
All right. Well, I hope that you'll accept the work that I have done the last 2.5 years to try and rehabilitate myself and make me be more careful in how I practice. And I hope that you consider my overall work as a therapist, and that in every way I try to carry myself very professionally. And I know it can look bad, but and trust me, I feel that I've tried to do everything as required. I'm not sure what else I could do. That your suggestion to maybe join a formal group is a good one. And other than that, I other than waiting out the rest of my probation, I don't know what else I could do. So I'm requesting if it's possible to have my probation terminated.
Thank you very much, Ms. Nicolaisen. I'd like to have the Deputy Attorney General give her closing remarks now. Ms. Crawford.
Your Honor, I would Thank you. I would waive any closing remarks. Thank you.
All right. Thank you very much. Well, with that, we have marked and admitted the exhibits 1 through 5 and her testimony from Ms. Nicolaisen. Mr. Disposti, is there anything else, or shall I close the record in this matter?
I think we can close the record, and then I will ask for a 30 minutes lunch break before we see our next petitioner, if my colleagues are okay with that. It looks
All
like,
right.
yeah.
All right, so I'm closing the record. Ms. Nicolaisen, thank you very much for your presence and your testimony. The board will be doing its own private consideration of your case later today. So thank you. With that, I'm closing the record, and I'd like the court reporter to stay on the line with me. So you can give me your estimate of page count. All right, we're off the record.
Your Honor, just for the sake of preparation, Ronald Austin will be our next petitioner when we reconvene at noon.
All right, 12 noon. Thank you.
Thank you so much. Resuming our public portion of our Board of Behavioral Sciences today. It's August 13. It's noon in the afternoon. And Your Honor.
Max, it's
Yes.
Kim, and I don't see that Susan or Wendy have turned on their cameras yet. We might still be waiting for them.
Thanks.
First Wednesday. Okay. And then Jonathan as well.
I can't turn on my camera because it says the host has kept you out.
What?
It says you cannot start your video because the host has stopped it.
Okay, try that now, Susan.
There you go.
There you are. Susan's on camera.
Okay. Thank you. Sorry.
No worries.
My impression, there is a quorum, but I will ask the judge to assess that, Your Honor. We can move to your portion of the proceeding. Thank you.
Thank you, Mr. Disposti. All right, I'm opening the record in the matter of the Board of Behavioral Sciences. Petition for modification of penalty of Ronald D. Austin. Mr. Disposti, was that the next case you had queued up?
Correct, yes.
All right, thank you. The agency case number is 2002-016-001-484. The Office of Administrative Hearings case number is 2020-070-585. I'm Administrative Law Judge John DeCure. Today is Thursday, August 13th, 2020, and it's approximately 12:02 in the afternoon. And this is a board meeting and hearing. The matters before the full board. There is not only a quorum, but every board member is present. So I'd like an appearance, please, by the Deputy Attorney General. Ms. Crawford? I think you're muted.
Shall we go off the record, Judge?
Let's just wait. Ms. Crawford, I still can't hear you.
Can you hear me now?
Yes.
Okay. Anahita Crawford, Deputy Attorney General, appearing on behalf of the Attorney General's office.
All right, thank you very much. And Mr. Austin, are you on the line?
Yes, I am.
All right, good afternoon. Do you understand that in an administrative hearing such as this, you have the ability to have a lawyer represent you?
I do understand that.
All right, do you choose to represent yourself today?
I do choose to represent myself. Thank you.
Okay. What we're doing is we'll follow a pretty simple hearing process, but if you get to any juncture and you don't know what's happening, I want you to go ahead and ask me. All right. But what we'll do is first, I want to ask you if you intend to testify on your own behalf.
Sure, of course.
Okay. For right now, I'm going to just swear you in then. Please raise your right hand. Do you solemnly swear or affirm that in the testimony you're about to give in this proceeding, you'll tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right. Thank you. We'll get to your testimony a little bit later. What I'd like to do is turn the attention over to Ms. Crawford so that she can take us through the exhibits that are going to be marked. And I'll ask you if you have any objections to any of the exhibits being admitted in evidence. You may not have any objection because there may not be any issue with regard to that. Some of them are your exhibits. So I still need to have them marked and admitted. Then we'll hear comments from the Deputy Attorney General. Ms. Crawford will speak. Then I'll turn over to your testimony and I'll give you a few pointers before you start. All right. So Ms. Crawford, go ahead.
Thank you, Your Honor. We do have 5 exhibits that we're seeking to introduce today. They have been provided to Mr. Austin. Exhibit 1 is the board's memo regarding the petitioner's probation status. Exhibit 2 is the notification of hearing to the petitioner of today's date. Exhibit 3 is the certification of registration history. Exhibit 4 is the petition for modification of probation and the attachments in support filed by the petitioner. And Exhibit 5 is the stipulated settlement and disciplinary order along with the underlying statement of issues. We would like those marked and introduced at this time.
All right, I've marked 1 through 5 as counsel just described them. Mr. Austin, have you had an opportunity to look at those 5 exhibits?
Yes, I have.
Okay, do you have any objection to those exhibits being admitted in evidence and considered by the board?
Not at all.
All right, there being no objection, exhibits 1 through 5, which are marked, are admitted. Ms. Crawford, would you like to make your opening remarks now?
Yes, thank you, Your Honor. This is Anahita Crawford. I am representing the state of California, and I am a Deputy Attorney General. I am appearing pursuant to Government Code Section 11522. My role is not adversarial, but intended to protect the public interest and to ensure that the panel has adequate information from which to make a decision. By way of a background of this case, the petitioner was issued his marriage and family therapist license on April 6, 2005. An accusation was filed on June 25th, 2018, which alleged the following. The petitioner met LR in 2011 when LR was a student in his class at a university. In 2013, LR asked petitioner to be his clinical supervisor, which petitioner refused. Nevertheless, LR filed a fictitious business name in Orange County, listing petitioner and himself as co-owners, and submitted forms to the IRS listing the business as a partnership. At some point, petitioner discovered that LR had added his name as an owner of the business and asked him to remove his name, though petitioner never verified whether LR did so. In March 2015, the petitioner agreed to be LR's clinical supervisor while he worked as an associate, even though LR was located in Southern California and the petitioner resided in Northern California. Petitioner was to travel to Southern California to supervise LR each weekend, but he did not always do so. Petitioner supervised LR from March 2015 to the fall of 2015. The petitioner was aware that to lawfully supervise LR had to be his employee in a private setting and sign a W-2 form. This did not occur. During his supervision of LR, petitioner did not train him on proper billing procedures. The petitioner signed blank billing forms, which he provided to LR, along with a social security number, and LR would fill in and submit the billing forms at a later date. The petitioner did not review or see the billing forms before they were submitted for payment. The petitioner also agreed to a fee splitting arrangement with LR for payments dispersed from the California Victim Compensation Program for services rendered to their clients. When the board began to investigate petitioner's actions, he told the investigator that he did rent the office from which LR practiced and that he rented the space to see a few EAP clients a month because he knew he needed to see clients in the same location that LR was practicing as an intern. Petitioner reiterated on multiple occasions that he paid the rent for the office space in which LR practiced, and that LR did not pay the rent. However, the property manager disagreed and told the investigator that LR actually paid all of the rent. When faced with his lie, petitioner did finally admit that LR paid all of the rent for the office space. As a result, the board filed an accusation which alleged unprofessional conduct, gross negligence and incompetence, and dishonest acts for entering into a dual relationship with LR, failing to educate him on standard business and billing practices, improperly supervising LR without following all requirements, aiding in LR's unauthorized practice as a registrant, and lying to the board. On January 10th, 2019, a stipulation was adopted which placed petitioner on 5 years probation. In addition to standard terms and conditions, he was ordered to comply with supervised practice, remedial education, costs, and probation monitoring costs. He is fully compliant. 3.5 years remain on his probation term, and petitioner is seeking to modify his probation term to remove the requirement of supervised practice. Thank you, Your Honor.
Thank you, Ms. Crawford. Mr. Austin, you don't have an attorney here to ask you questions in the initial part of your testimony, which is called direct examination. Typically, a lawyer will know what high points they want you to hit and essentially give you those high points by asking you specific questions that will lead you to one subject and then another and another. So since you don't have somebody here to ask you questions to bring out your testimony, you'll be allowed to make a narrative statement as your direct examination. And a narrative means basically you're telling your story. I give one generic suggestion to people in your shoes. And that is that first, I think the one thing you want to avoid is to leave holes or blind spots in your testimony and then realize later, oh my goodness, I left out something important. So to give a comprehensive statement, it may be best for you to go chronologically. Now that's just a suggestion. You can testify however you like, but once you're done with that, there will be cross-examination, and I'll give you a few pointers about how that's a little bit different than what you may have experienced before and how you can handle that. For right now, it is possible that either I or Ms. Crawford would object to something that you state. I have the discretion to make a legal objection. Ms. Crawford does too. So if you hear either of us make an objection and break in, just stop talking. We'll deal with it and then we'll move on. All right. So are you comfortable?
As comfortable as I can be considering.
Okay. So go ahead with your direct testimony.
All right. So what I'll do is I'll do like you said. I've watched the other cases this morning. I want to say up front, first of all, it's my birthday. So maybe, I don't know if that helps any, but, and then secondly, I actually am usually very brief by nature, but try to really hit points. So yeah, by all means, if there's something that I miss and there are questions that come up, please. My goal today is twofold. It's yes, to lose the clinical supervision, but it's also to gain your guys' insight. Hold on, something popped up. To gain your guys' insight into what maybe I should be doing to be able to get off of the probation the next time I meet with you guys. Because that's the difficulty, right, in this process. It's like, follow the probation guidelines, but what am I supposed to do? What are you guys looking for? So that's really kind of the twofold. So I definitely would like to be off clinical supervision, and we can talk about that in a minute. But I want to address the issues that I caused. Ian, for a few years after I knew the other gentleman, we'll just call him, he kept wanting me to clinically supervise him, and he moved to Southern California. I live up here in the Bay Area, and I said that's not humanly possible. And you also need to find somebody down there. As years went on, my mother was ill, and I was going down to Southern California a lot. So I tried a little pilot program. Much to my dismay, I did everything about it wrong, and can admit that. But with that said, some of the things in the investigation report, I'm not 100%, with. I get it that's the investigative report, but I did actually supervise him every week that he had clients. Sometimes I would talk to him on a Saturday regarding clients from the week before, and then on a Sunday regarding anyway, it worked out to where the logistics, I really didn't lie about if I supervised him in a week or not. What I did lie about, but let's hold on a second, okay? We'll go timeline. So I supervised him from March to September 2015 in Southern California. That is a fact. And then in December of that year, he tried to bill, and I only did one client because I wanted to see how this was going to work out, how we were going to handle the payment and everything. And during my testimony, please know that I recognize that some of this stuff was completely not okay to do, but I was trying to sort it out on one client. That doesn't make it right, but that's what I was trying to understand. How could I possibly do this with this gentleman that was requiring supervision? In December, he billed for this client, and in looking at the billing even again, I'm not sure what number he used initially to bill. It was some type of either Social Security or tax ID number. When I went through the investigation in 2016, I had thought that he actually had already done an ID, a tax ID for both of us. When I look at it now, I see that in fact he didn't apply for that employer identification number until he billed for that one client. Because what it shows is when I went through the employer identification number with the IRS, he actually applied when it got kicked back, the billing, and then he applied for a tax ID number for both of us. So to the point where the errors occurred, there was no joint tax ID. There was a joint tax ID though, and I was aware of it. And I did not go and, take care of it before the investigation. 100%, that was my fault. But in the initial investigation, I thought he had requested that tax ID back in 2013. But what had happened is he requested the tax ID in 2015 and said the business started back in 2013. Nonetheless, it's a lot of information to say that, I definitely should have checked immediately once he said there was a joint tax ID, because I know that's not an allowable way to supervise someone. So that was when the Victims of Crime Services referred the matter to the board to investigate based on us having a joint tax ID. And then, as was stated, I did lie about whether I paid rent down there. That was going to be taken care of after we got payments. I recognize now that was not an okay way to do it, and I can't stress enough how humble and embarrassed I am that I lied to the investigator. I did it both in writing, and then she asked me point blank, "Did you pay rent?" And I said yes, and then she talked to the landlord and found out that I did not. And so I just admit that, and I can't be more sorry to the board that I did that. So that was in 2015 when he did the billing. The investigation took place in 2016, and then I kept checking because I did supervise other people within nonprofit agencies, and I didn't want anybody to have any issues related to the issues that were coming up for me. So I kept monitoring my license, kept monitoring it, and 2.5 years went by, and I wasn't sure if there was going to be any thing that came up from the investigation. And then in July of 2018, I received the notice from the board that in fact there would be some things happening against my license. Then in July 2018 to September 2018, I negotiated the conditions of probation. I decided to not use a lawyer, and then January 10th, 2019, probation started, and between January and February, I located a clinical supervisor, got all the forms set, and have been doing clinical supervision ever since. And I started that in February 2019. The other condition of probation was that I complete an in-person law and ethics course. Believe it or not, those are a lot harder to find than you could imagine. Now it's impossible, of course, right? But back then it was super hard, and my probation monitor was very helpful in finding the one in-person law and ethics class that was nearby. And I worked with my employer to get the right timing off so I could attend that class. So I've completed that. I paid all fines, monthly recovery costs, and so I'm sorry, I am a little bit nervous because this matter is different than the other two you heard, and so I have no idea how to really relay what's going on. But I can say that, let me just take a big breath here. I can say that in this whole experience, I have learned that you can make lemonade out of lemons, and the experience I've had with the folks that I had to negotiate with Miss Lane in Southern California, the conversations I've had with my clinical supervisor, the work we've done to make sure that I'm ready to have a free and clear license has been very valuable. And he submitted a letter. In the letter, he talked about, I definitely use him even outside of the clinical supervision if there's something coming up. Because in my mind, the only way to have this be different is to right off the bat do things differently, which is consulting with him, which is being open to having every decision looked at, and honestly, forever. And that's what a professional should be able to do. And so I think what happened in this situation, besides the lying, which is just not okay, but in this situation, I bit off more than I could chew in allowing his constant request to supervise him to then go ahead and do that. So the nice thing about that is, so then I know, check with colleagues, make sure that I'm not making errors in decisions like that, because that should have been a pretty easy decision to just continue to say no. So I think that's about all I had to say. I think that kind of says the whole matter. It seems a little muddled to me, but I hope you understood it. Thank you.
Thank you, Mr. Austin. I'd like Ms. Crawford to ask her questions first. Go ahead, counsel.
Thank you. Good afternoon, Mr. Austin. I'm going to see if I can attempt to unmuddle your story a little bit.
Thank you.
So you can have an opportunity to present your story. How did you know LR? Student?
He was a student.
Okay. And you were teaching at a university at the time?
Yeah.
How long had you known him at the time he approached you about supervising him?
So he had been a student. So there's the student piece of it, that was years before. So I think the last time I had him in a class was like in 2010, right? Maybe even 2011 at the latest, yeah.
Okay. And he approached you, was it in 2013, about supervising him?
2012, 2013, 2014. Yeah, he kept wanting me to supervise him. He thought that I would be a good supervisor.
Why did you initially refuse to supervise him?
Well, like I had said, he was in Southern California. He moved there after he got done with his graduate work. And I said, there's no way I can do that.
But at some point you did kind of acquiesce and succumb to his multiple requests, right?
When my mother was ill and I realized I was going to be in Southern California a lot, I thought, well, then maybe I can help this guy out. Maybe I can supervise him on this one victims of crime client, and I can learn a lot about how to supervise victims of crime clients, how to handle this. Maybe this is an area that I would go into at some point.
So up until the point you agreed to supervise him, he did not have any kind of supervision, or he?
I don't know. I don't know. I really don't. Yeah.
So at what point did you discover that it was your name that was listed on the business as a co-owner?
Well, he told me, when I think back on it, and I can remember having a phone conversation with him, and I want to say it was like 2014, where he was like, oh, I'm going to start a business for the two of us. And I'm like, no, you can't do that. And he really did not understand. He could not do that. I told him, you cannot do that. It is not allowed. It's something that would actually get us both in trouble. And then at some point, I could swear that he said, I did it. But I just said, you need to, undo it, whatever you did. And honestly, I didn't do anything more. And
right.
then.
Well, let me stop you there.
Yes, go ahead.
Let's kind of take it piecemeal.
Yeah.
So you didn't do anything further. At that point, this was an individual who had told you he wanted to start a business with you, and you said he couldn't, and then he went ahead and did it, and you told him to take your name off. Since he had already established that he wasn't one to listen to you, right. Why did you trust that he had taken your name off?
I'll be honest, I don't know that I trusted that he did, but it had nothing to do with me, right? It was an error in my thinking. If I believe, now I see that. If somebody says, hey, I filed joint partnership papers, I need to go take care of that immediately. But in my thinking, which was erroneous, had nothing to do with me. You know what? I don't got to do anything, which was wrong. But that was why I didn't do anything. Okay. Go ahead.
Okay. And I wanted to also talk about the billing forms. There was
Yes.
statements made that you had signed some billing forms ahead of time that LR could then sign and submit. What were the circumstances around you doing that?
And again, I feel bad for the investigator because, and I'm not, when I discuss this is no ill will towards the other person, but he gave her a run for her money as far as reaching her, giving information, all of that. And so really the billing forms, what happened was I signed off on them with him. But then when it was I did not look closely at the employer identification number, and that was an error as well. But then when those came back, then I signed forms and I told him to use my social security number, and he did not. That's when he applied for that EIN that's under us both. So my error was signing the form, not knowing what the tax identification number was, not making sure my social was in there. That was my biggest error of all, because then when the victims of crime kicks it back, then that's when he applied for the joint tax ID. So he never really had applied for that joint tax ID. But again, and I admit all of this, my error of not knowing, right? So that's where the errors lied.
But my understanding was that
Ms. Crawford, I'm sorry, this is Judge DeCure. Here's the thing. I can sustain my own objections, Mr. Austin. Okay, I have the discretion to do that. What my objection would be to that answer is that it's non-responsive. Okay, you've got to have a bit more faith in the question and answer process. Ms. Crawford is a Deputy Attorney General who's experienced at questioning witnesses. What happens on cross-examination is one thing, okay, and one thing only. And it's going to be the same when the board members ask you questions, because I know they will. You have to listen really carefully to the question itself. what does it call for? Then you give your answer to the question and stop. Okay? You've already told your side of the story, so to speak.
Okay.
Right now, you've got to be more focused on answering each question.
I appreciate
it. I know you said you were on the line this morning. We've had varying degrees of petitioner's ability to do that. I want you to call on yourself right now to focus only on one question at a time, answer that question, and then have faith that another question will be coming. I guarantee you it will. Okay, thanks so much. Ms. Crawford, go ahead.
Thank you. Mr. Austin, I had specifically asked about the billing statement where the accusation indicated that those billing statements were billing forms were actually blank, and that you had signed them ahead of time for LR to submit when he was ready to submit them. It was that circumstance I was asking you to tell us what was surrounding you signing forms that were actually blank.
Okay, so when he had to redo the billing, then I signed blank forms and faxed them to him and told him to use my social security number.
Okay, and why did you think, or did you think that was appropriate at the time to do?
I think the error there was that I thought I thought we wanted to. I did think it was appropriate to do, and that was an error in thinking. Yes.
Okay. And why did you provide those blank forms to him to submit?
Because he had already billed, and the only issue was the tax ID, and so I thought I could submit them to him, say, use my social, let's get this done.
Okay.
I should have supervised it more closely.
Okay. And this requires, my next question requires perhaps some explanation on your part to me. Another fact that was stated in the accusation was that you had a fee splitting arrangement with LR. And as a supervisor of his work, why were you entitled to bill for the work and then split that fee with him?
That was an error.
Okay, so who would have billed for that work? That would have been LR to bill for that work, correct?
Yes, it would have been him that bills for the work, but I sign off on it, yes.
Okay. And then you said it was an error, the fee splitting. Would you have any point been entitled to any part of that fee as a supervisor?
Yeah, the way it should have worked is I would pay him an hourly fee. That's how it's supposed to work. And then when the money comes in, it's mine or the business's. Because I was trying this one client out, that's what I meant earlier when I said I made mistakes trying to do it this way. I thought, well, let's wait to get the money and then pay him and pay the rent and all that. But again, you know.
Okay. And I know you've also reiterated multiple times that you did make the mistake of lying to the investigator about renting the space. What was your motivation in lying to the investigator about that?
There was a letter from the landlord that we were current in our rent. And so I didn't want that to be another issue. I hadn't done a W-2, so I didn't submit a W-2. You know what I mean? I didn't submit any false documents, but I thought since there was a document that stated we had paid the rent, I would just say yes.
The document stated who is we in
The
that?
The landlord submitted a document and it said that all rent is paid in full or something like that. I found it when I was looking through my information the other day, and it said, so that was why I made the error in lying, was it seemed like it. Yeah.
Okay. So you felt there was kind of an element of truth in that the landlord had said the rent was paid up.
It was a lie. I lied. You know what I mean? Like I'm admitting it that even though there was a letter, I knew that I had never paid rent there, and I admit to you all that I lied to her.
And that was the question I was asking, was what motivated you to lie about that rent to the investigator?
I thought that not submitting a W-2, what kind of trouble could I get into? Everything else kind of snowballed, you know, from the lying about the rent. And that makes sense because I lied. I totally get it, right? But in the reason for lying was I thought, well, why have one more thing besides the W-2 that I didn't do or I did wrong, right? And then since the letter came from the landlord, I thought, okay, I'll just say I paid the rent. I feel horrible even discussing this, to be honest with you.
Understood. And I certainly don't mean to berate you over this at all.
Yeah.
It's more that the board needs to understand from such egregious conduct, which I think you agree this is, how you have turned this new page. How have you rehabilitated where the board can be assured that one lie is no longer even going to be something that you'd be willing to do, leave alone multiple?
You want me to answer that?
Yes, please.
I love my career. I love like everything about this work that I do. And if I could take that lie back and just, just know that just like in this, being clear on the answer, I love what I do and I'm very good at it. And so that alone, if I get in trouble again with the board, for lying or for anything, my career's over. I appreciate the fact that my employer kept me on, that you guys offered me probation, all of that. And it's insane that it's over a lie like that. But so it's easy to see now that any lie is not okay. Mostly because I love my career.
You're asking the board to terminate the condition of the supervision requirement. What have you done to comply with that supervision requirement?
I met with him every week, and we discussed the cases. We've discussed anything that might be coming up for me. It's a little tricky in this situation because the issues are around the supervisee, right? But everything's been fine with the clinical supervision. Like I said, I actually appreciate the ability to reach out to him when it was necessary during the last year and a half.
Have you learned anything in your law and ethics courses about this incident that really resonated with you that you'd like to share?
Yeah, I would. When I took the in-person law and ethics course, of course, I've been licensed for a number of years and done a lot of good things in my career. The course was with newer folks, and I really saw how easy it could be for any of us to get caught in ethical dilemmas. And so a lot of that course really was about discussing ethical dilemmas, how to avoid them. It was super helpful to be with folks who were newer and to make sure that I was learning about the ethical dilemmas.
And why would you want to remove that supervision element of your probation at this time?
Everything has been fine with the clinical supervision. I understand that at a year in, I'm allowed to request that. He and I have enjoyed our supervision, but it also has a cost factor to it. It has a time factor to it. And both of those things, while I'm fine doing it if required, it definitely would be helpful to not have that Now we're doing it, online because of Corona. But before I was driving to Sacramento an hour. I'd have to find that time in my schedule. I'm having to see clients on the side because a part of the probation was that I see clients, and so I'm having to see clients, and I'll continue to do that. Having to have my clinical supervisor, having to pay him. So that's why I'm requesting that the clinical supervision be dropped.
Are you currently in therapy?
No, I am not.
Have you sought out any therapy around the issues in the accusation in order to review what you did and why you did those things and how to come away from that?
What I belong to is a consultation group of 3 or 4 other individuals. And right when this happened, I made sure that, I brought this up with them, that we discussed this as we were going along. Of course, it was, after I had lied. And so I shared that with them. And so, we discussed, these kinds of situations and that.
Thank you. I don't have any other questions.
Thank you.
All right, thank you. This is Judge DeCure. Before we turn over questions to the board members, I just wanted to ask you to follow up on one of the answers you gave. Why is it that you're seeking to have this particular condition removed from your probation? Could you restate that? I want to make sure I understand you.
First of all, I don't think that it's, after consulting with him, I don't think it's necessary at this time in relation to my individual clients. Also, there is a time commitment to it and a monetary commitment to it. And I'm hoping that the board can see that the clinical supervision piece, has been compliant and effective. I have had no issues with client care. That's not been a part of this. We did the clinical supervision because it was required. But I'm just not sure that it's, it seems like it would be appropriate to end it in my humble opinion.
Thank you, Mr. Austin. So we're going to turn to board members' questions. And remember, Mr. Austin, you want to focus on one question at a time, listen carefully to the question and answer it, and we'll move on. We'll start this time with Ms. Wong. Ms. Wong, do you have any questions?
Yes. Thank you, Judge. So Mr. Austin, thank you so much for providing the information about your case. And I think that really helps to, shed some other lights of the holes of this, the situation. So there are some factual things I want to clarify. Sure. So in regarding to LR, do you guys just work on one case, or how many cases that you guys actually worked on?
Well, so this was a number of years ago. We had just one case, and it was for 5 or 6 months.
Okay, so that is only that particular case in regard to the Victim Compensation Board.
That's right. It's the only case he had, period, that I supervised him with.
Okay, and so, so what made you change your mind, to, I know that you talked about, you want to, have a, pilot program, use that as a pilot program, and then you did everything wrong.
Right. Sorry.
So, yeah, right. And so I really want you to elaborate, what is your understanding that kind of, give me kind of like a laundry list.
Sure. Of what I did wrong or?
What you have done wrong, yes.
Okay, all right. First of all, if it was only going to be one client, now looking at it, and it's the distance, it was just the wrong situation to start. So, instead of trying to make something happen in the future, I would just be like, no, go ahead and find somebody in your area or whatever you need to do. So that's mistake number one, finally agreeing to supervise him at where he lives at a distance. The other mistakes were, any other time I've done clinical supervision, it's been with a county agency or with an employer of some sort. So this was my first time trying to do this in a private practice type of way. And so I realize now that I should be paying him an hourly wage. That should be based on a W-2 that he has. It should only be done at my place of employment, end of story. And then whatever I do, then the other errors that came up was the billing error and not supervising the billing both times on the front and the back end.
Okay, so so this is obviously a client. I mean, I'm talking about that one single case now that you talked about. So the not insurance, the basically, the billing, the place to submit the billing is the victim compensation board, and they have actually very, very specific criteria.
Yep.
In order to be eligible for the provider, and then in order to eligible for billing. Right. So can you maybe, can you speak a little bit more about that also? What went wrong? Because we do have public members that probably doesn't quite understand, the billing and what really it means by, you supervise one person and the fee, I hope it, it makes sense to you. So I want you to speak a little bit more about what really is that, what is that about? What should happen, when you work for victim, compensation board?
Well, there should be a lot more oversight because you're right. There's a lot of specific rules related to the victims of crime compensation. Is that your question?
Yes. I really want you to kind of like educate the board now. This already happened, and that's fine. But at the same time, now, sometimes when we have to look back to our mistake, it's also very important that you kind of know what you have done wrong and what should have been done, right? And so I want you to really educate, our board also, what should have been done, and also, yeah, go ahead.
It's interesting because I'm trying to be very specific to your question. What really should have been done is I should have been consulting with somebody else that bills victims of crime, because I've only done clinical supervision for clinical, not for billing, not for, renting an office, not for anything else. And so I went in and I helped him, and I had no idea the specific billing practices. And so, and I kind of like look back at it very disappointed, because it would have been pretty easy to consult with victims of crime folks who already bill it and just adopt their system and away we go, right? Where I really, that's what should have been done though.
So, so supposedly, it should be the licensed person who did the billing, instead of.
That is right. You're right. Yes.
And so it means that, when the intern really wanted you to, to be part of it, to get your social security number and whatnot, he was actually following the rule. Right? I mean, I'm just trying to, get.
No, sorry, no.
Okay.
Yeah, because he applied for the tax ID number. It had nothing to do with my social at that point. He applied for that instead of using my social security number. But I knew that it had to go under me.
Yes.
Yes. And so I knew enough of the rules. What I'm saying is when it comes to billing with victims of crime, I wasn't squared away enough, and I wasn't supervising close enough with him. No, I was not.
Okay. All right. So, so it looks like, being very, very careful, it's, a lesson for you to learn. And so, now interesting thing is like, because when you did, so when you are supervising him, that, and then have the fee arrangement, you basically at that point enter into a very, a dual relationship.
Right.
Right. And so, so have you thought about that, that is actually, not having a formal employer and employee, or supervisor, not supervisor, that just makes it more complicated. I mean, how do you avoid that in the future?
when I don't want to minimize what I did, because hopefully you can see that I'm completely remorseful.
I didn't say that. Yeah.
But the piece of it that I forgot your question.
So, so when you agree that, because you don't have a private practice with him, you do not have even a private practice, end of story. And then you agree, for him to, to bill and basically lie to, the victim compensation board investigator that you do have, a private practice, even though that private practice was, belonged to, your supervisee. So when I really want to understand your thought process because, why wouldn't you, be aware that, by just having that arrangement, not only is about the supervision, but really it's about entering into a dual relationship.
I understand completely. And I was trying to make something happen that I shouldn't have tried to make happen. You know what I mean? Because when I look at it, I don't bill insurances when I see clients. None of that do I do for me, right? And so I knew I was out of my scope in that situation. And so, like I said, what I really should have done was had, another business. What I would do in the future, if there ever came up billing, I would just hire a billing company to do that piece of it, work with me, make sure I understand it. My forte is not in the billing. And it wasn't something I even was going to do, but then I got caught because I thought I would just do this pilot with him. And again, my explanation to you is my thoughts on it. I'm not suggesting that it was the right thought process.
Okay. Thank you very much. I have no more questions, Your Honor.
All right, thank you. Ms. Strack, do you have any questions?
Yeah, just one question that I'm kind of struggling with as I'm listening to your testimony. Seems like there was just a lot of red flags here with this particular individual, and yet you kind of kept, creeping along that path. And now you're not even halfway through your probationary period. You're just shy of 2 years. And the supervision element is sort of one of the major elements of oversight. The remaining items are more procedural and reporting. So I'm kind of struggling with why in such a short time period into the probationary period is this the right time to remove that supervision? I think that's just, I'm struggling a little bit with that. So if you can shed any light on that, that would be helpful.
Well, I hear what you're saying, but I guess both my clinical supervisor and I are wondering what the supervision would do relative to the issues at hand. You know what I mean? He's seen no issues with my client care. And there is no billing that's going on. So I guess, I guess that's why I think it's okay to remove the clinical supervision piece. Is I'm not supervising anyone. I'm not, you know what I mean? And so that's why I'm requesting it at this point.
I don't have any other questions.
Thank you.
Thank you. Mr. Sovek, do you have any questions?
Yes. And before we begin, I just want to confirm with you the pronouns you would like me to address you with.
He or him.
Okay, thank you. So I actually have two questions. This supervision relationship started in 2015?
Yes.
Okay. Before then, had you supervised other people?
Yes.
And what coursework had you taken to set yourself up for supervision?
Every year, if not every 2 years, but usually I would take a supervision course every year, sometimes in person, sometimes online.
Okay, so before this 2015 arrangement, you had taken your 6-hour supervision training?
Yes.
Okay, thank you. No further questions.
Thank you very much. Mr. Ranisinger, do you have any questions?
Mr. Austin, you mentioned on cross-examination that you were part of a consultation group during the period of time where you lied to a BBS investigator. Is that correct?
Yes.
you also mentioned that after you lied, you discussed that with your consultation group, right?
Yes.
Were you discussing the problems that were occurring in this business with your consultation group while they were occurring?
Yes, I brought up the stuff that was going on, yes.
Okay. And after you lied to the BBS investigator, was that topic brought up immediately with your consultation group?
Yes, immediately.
Okay. All right, nothing further on it.
Thank you very much. Mr. Maddox, do you have any questions?
Yes. So Mr. Austin, I'm a preface just by saying I'm one of the licensed MFT members. I am a program manager. I've been a clinical and am a clinical supervisor. I have worked in private practice. And so I just kind of want to lay that foundation just for the couple of questions that I have. I have not really heard any sort of rehabilitative either activities or insights that you have gained in our conversation today. And I appreciate everything that you've shared, but I haven't heard anything. Can you help me? Will you tell the board what insights, let's keep it away from insights, what rehabilitative activities you've engaged in besides what you've already shared to, one, develop some insight into the choices you made and sort of how you've learned from them?
Okay. Well, besides the consultative group, I have talked with a number of colleagues that I respect and, work with them on, discussing cases, trying to make sure that that I'm continuing to develop and to stay away from the decisions that I made. I hear what's being said as far as the rehabilitative process. So I've done that a lot. I use the clinical supervision, to discuss any things that come up in relation to, if there are ethical decisions or dilemmas that arise. In all the other things that I shared with you, I don't need to read.
All right, thank you. Thank you. Can you help the board understand why, as a therapist, after having made the choices that you made, you have not sort of volunteered to go to therapy yourself and actually work through the choices you made? And this is my last question, then I'll make a comment. Because the things you're describing, peer consultation groups, supervision, that's always with a peer. And so, you may or may not get any sort of insight out of it, depending on how much time is allotted to you to manage something. So I'm wondering why you have not volunteered to go to therapy and figure out why you made the choices you made.
Well, that's a great question. I don't have an answer for that, but thank you for the question.
Okay, no, I appreciate it. And so I don't have any more questions, but I do have a comment. So you initially started this conversation by saying you'd like to be able to gain some insight about what might be helpful to get off probation at some point early. One suggestion would be is that I think probationers who are able to do that, they have engaged in activities and demonstrated a significant amount of insight and rehabilitation related to the challenges that brought them to the board. And I'll speak for myself. I'll say today's conversation has been very disturbing because to me, it doesn't seem like, one, you understand sort of the core issues that are at hand here about why you decided what you wanted to do. And you've also not engaged in any activities that would actually lead you along that path so that you could. So my suggestion would be, I would volunteer to go to therapy and work through some of these so that next time you choose to come back, you can articulate some of those underlying concerns and things that you've learned so that you can avoid making the mistakes that you made again. So thank you for your time, and I'm done, Your Honor.
Thank you, Mr. Jones. Do you have any questions?
I do. Mr. Austin, thank you for appearing today. law and ethics are at the core of what we do to protect our consumers and our clients. You know, law is the thing that we have to do. Ethics are the things that we should do. To echo Ms. Strack's comments, there were a lot of red flags that came up around your supervisee. And you know, I'm an educational psychologist. So that's my role. I look at patterns of behavior. So with regards to the observance of the patterns of behavior of this supervisee that continuously asked you to supervise him, and you said no, 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 and then kind of caved into to him for whatever reason that was. It feels to me like there was a lot of, and you've said this, poor decision making. What assurances do you have to the board that you're not going to make those same decisions the next time an opportunity like this comes up again?
Well, I think if we don't learn from our mistakes, then that's the toughest part, right? And so, I mean, I'm in a lot of trouble with my license over, you know, acquiescing to this gentleman's request and all the red flags that came, you know, before it. And so, you know, it's a horrible example of my work. I have a successful career. I've worked for 3 different counties. I've done a whole bunch of different things, and I don't know if this is the right place to say that, but this error, I for some whatever reason decided to help him, and then the snowball happened, right? And so Mr. Maddox's question and comments make a lot of sense. They didn't before, to me, honestly. I thought, well, I'm taking care of my terms of probation, and that's where I start in the beginning. Anyway, I can only tell you that is my word that I would not, you know, do those kinds of things again. That I would actually be involved more, you know, in a group. If I'm dealing with any employees at all, I would have others making decisions, not just me. So hopefully that helps a little bit.
Thank you. No more questions.
Thank you, Mr. Jones.
Thank you, Mr. Jones. Ms. Friedman, do you have any questions?
Yes. Mr. Austin, thank you very much for being here. The one part of your story that sticks with me a lot is you're lying about paying the rent. And a lot of people lie very, very much often because they think it's the fastest way to get rid of something, that it's easier to lie in that situation. Or they may lie to maybe not hurt somebody's feelings, whatever. Have you ever lied in your life about other things that have nothing to do with your practice or your professional life?
I'm sure I have.
So that is something that you may want to work on, because I know a lot of therapists and psychologists, and they tell me all the time, the one thing I will never ever do is lie, even to protect someone's feelings. So that may be an area that you want to look more closely at in your own life. When you asked about, you know, what you should do for the remaining time that you have on probation. I don't have any other question.
Thank you.
Thank you very much. Mr. Ehrlich, do you have any questions?
Yes, I do. Mr. Austin, do you, if probation were to be terminated early, or when probation expires naturally, do you plan on also engaging in clinical supervision again?
You know, it's interesting you asked that question. I definitely enjoyed it a lot through the years, but I don't know. I don't know. There's a part of me that really does want to go back and do it again. Want to come back and prove to you all that you know, you're, you know, that you can trust me. That's more important to me right now than even that. But right now, I do not know. And if you would have asked me that question up until today, I would have said, yeah, I want to, but I want my career back. I want my license back. I want to have a job that I know that I don't have all. Clinical supervision is a very messy thing. And don't get me wrong, I made the mess. I'm not trying to suggest somebody else did, but it's way more messy than any other thing that I've dealt with. And that's why I stayed away from private practice supervision. And then this one time
Well, and I understand your answer. The only reason why I ask is I know board member Streck asked about, the one request you have today is to remove your own clinical supervision. And your answer, you talked about, you and your supervisor talked about what really is the need to have this, since, you're not supervising anyone. So that was my concern, is that if you don't feel that there's a need to have the supervision right now, but yet, like you just said, up until today, and even now, we're still not sure, but up until today, your intention would be, yes, you probably would engage in supervision again. That would be my concern, is that if you feel like what's the need to have this as part of your probation, this is kind of the root cause of why we're here. So I would just wanted to voice my concern with, the sort of feeling that you're expressing of not sort of needing it or seeing why you need to have it right now. And I have no other questions.
Thank you.
Thank you. Ms. Brown, do you have any questions? Ms. Brown, you might have your mic muted.
At this point, I think I don't have any other questions. I think they've been asked and answered.
All right, thank you very much. Dr. Brew, do you have any questions?
I don't have questions. I have a comment to maybe add to what others have said about what he can do. So thank you, Mr. Austin, for coming. And this really has been helpful in trying to understand what went wrong. And the way I'm kind of conceptualizing it is that that you practiced outside of your scope of competence, right? Without seeking consultation. And I'm guessing it's due to some sort of countertransference issue that emerged when LR was so persistent with you, maybe related to codependency or people pleasing, I don't know. So to piggyback of what everyone else was saying, you might explore like the reasons that because to me, you definitely had a red flag. You felt that red flag. You had concerns and you didn't listen to it. So I just want to encourage the idea of therapy if that's something that you can find time to do, and in exploring that, because that countertransference problem can come up again, even in your regular clinical work or with supervising at an agency. So it's really important to know ourselves well enough so that we don't make at least that particular personal issue that's going on that you have that. So thank you so much for coming.
Thank you.
Thank you, Dr. Brew. Ms. Anthony, do you have any questions?
I have no questions. Thank you. Thank you for your time.
Thank you.
All right, Chairman Disposti, do you have any questions?
No question as well. Thank you so much.
All right. So what we'll do now is, well, we've been going for a little over an hour. We should just keep on keeping on. And with that, what I'd like to do is allow you to make summary remarks to the board, Mr. Austin. This doesn't mean that you are going to have to reiterate anything that's in your petition, because that's already been marked and admitted and will be considered by the board. But really, at this point, probably the best thing you can do is summarize why you think the board should do what you're asking them to do. Go ahead.
Okay. I do believe that clinical supervision being removed from probation would be a fine thing, even though there might be some things that the board has brought up that they may have They may or may not think so. I don't know, but I'll try to explain why I think it should be still okay. When I'm doing clinical supervision, it's regarding the clients that I have presently. I have a few of them on the side of the other works that I do, and he and I talk about those clients. The suggestion about therapy before coming off of probation, that makes a lot of sense to me in looking at like the countertransference issues, the why I went through even with red flags, the continuing of learning about, if I want to do business, then learn the business, but don't react to a request just because it's continual. I'm having a hard time, and I think over the last year and a half, seeing how continued clinical supervision is the answer to that. I can tell the board that if the next time I see you and if you do remove the clinical supervision piece, that then I would be going full at it with the therapy piece. It's very expensive. I have a $200 a month cost recovery fee. I have $500 a month into clinical supervision, and to afford private therapy alongside the clinical supervision, along with the time elements. I'm just being realistic. It's very difficult. I also do feel like I've been completely forthright. I also, I get way more nervous when looking at these types of things, and you're not able to see the real me. You probably are used to that, but I do believe that you have a therapist in front of you with lots of experience, lots of energy. I love training folks. If I never supervise again because of this, I will live with that. But there's so many things that I'm kind of on hold for with the license the way it is. It's impossible to go out and get some other employment. My current employer has been awesome in working with me, and that is not a reason to give me to stop clinical supervision. I'm just saying the process towards getting my license back, it's kind of impossible to do clinical supervision and therapy and consultation groups, as well as a full-time job, as well as, and I'm as emotionally overwrought as the other two people I saw. I just don't cry, right? I have kids, going to college. I have all of that stuff going on. And yes, I agree with everything you guys have said. I missed multiple red flags 5 years ago. The process of having the board do this, the process of going through the negotiations, paying the fines, all of that, if that doesn't help somebody, I don't know what does. I completely hear what you guys are saying, and I respect your judgments today, next time I see you, all of that. But I really do look forward to having my license be free and clear. And I look forward to, if when we meet another time, you see the things you want to see. It's been complicated because it's an issue over here, and yet I'm getting supervision over here. You know what I mean? So that's really all I have to say. I think we all understand the case now.
This is Judge DeCure. Thank you, Mr. Austin. I'd like to hear closing remarks from Ms. Crawford, please.
Thank you, Your Honor. The board is guided in such cases by Title 16 of the California Code of Regulations, Section 1813. And some of the criteria the board would need to consider in determining petitioners, whether to grant petitioner's request, is to look at the nature and severity of the acts, and to look at the rehabilitation that has been submitted by the petitioner. Here we know that the petitioner has admitted to what he terms as mistakes. He was hesitant about taking on LR as a supervisee, but he did do so. He told LR to remove his name as a co-owner, but didn't check to make sure he had. He supervised him despite not having a W-2 for LR, not being employed or an employee. He supervised him despite not renting space within which LR practiced. He allowed improper billing to occur, agreed to fee splitting arrangements that was not proper, all of which demonstrated a lack of good judgment and dishonesty. So in light of the nature and severity of these acts, the board needs to consider whether petitioner has demonstrated rehabilitation such that the board would no longer have concerns that these acts of, that this demonstrated act of lack of good judgment and propensity for dishonesty would not inject itself into a petitioner's clinical practice. And so that consideration is something that the petitioner needs to have shown that his clinical practice would not suffer from his demonstrated lack of dishonesty and good judgment, and therefore that the clinical supervision would no longer be necessary. Thank you, Your Honor.
Thank you, Ms. Crawford. Mr. Austin, we've reached the conclusion of the hearing, and the board will consider your case in closed deliberations at the end of this afternoon. So thank you for participating, and we are now on closing the record, and we're off the record.
Okay. Thank you, Your Honor.
Really quickly, Mr. Sanjeet, the time and the page number, please.
Good afternoon, Your Honor. An official stop time of 1:15 p.m., a page count of 42 pages.
Thank you. Go ahead, Mr. Chairperson.
No problem. It's 1:15. We can take a break of 10 minutes and reconvene 1:25. I believe our next petitioner will be Robert Nelson.
Thank you.
Thank you, everyone.